14th of 2025.
Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live, where apparently I have messed up my thumbnail today. It should have said Judgment Day on it, because here at the TCF bunker, the sky has suddenly become as black as sackcloth. It's frightening out there. Speaking of frightening, let's see what's going on in Miami-Dade. We'll start with Mindy Glazer.
Or not allowed to go to that store, and you must stay away from there. There's probable cause. Bond is $2,500. Have a nice day. Did you need David Espinal Mendoza? Who's number 52? Let me see.
He refused, Your Honor. I don't know why she.
Okay, let me review. It's an added charge, battery by detainee.
We'll waive his.
Appoint the public defender's office. Waive presence. There's probable cause. I'll set the bond at $1,000.
Judge, they go out of camera and they fight.
He's the one who grabbed the tray, guys. Victim's food tray. So he started.
What was the bond?
1,000. Okay, now we have Bertha Freitas, each one.
Bond out.
You see bond out?
I did. 1 to 3.
Bond out. Good way to start. Nakia Anderson. Oh, hey, get that right.
Miss Anderson is present.
Wait, now I can't. Thank you. Good morning. 1 second, please.
Is there added charge corrections? Yes.
All right, good morning. Ms. Anderson, you were arrested for grand theft. It's an added charge. It goes back to April 27th of 2025. I will appoint the public defender's office for you. It's happened at Aldi. $1,000 worth of groceries. That's like all the stuff in a store. That's a cheap store. Inexpensive, not cheap. Anyway, there's probable cause. You're ordered to stay away from the Aldi supermarket at 15033 South Dixie Highway in Palmetto Bay, Florida. You're not allowed to go to that store. You must stay away from there. So I'll set a bond, $2,500. Have a nice day. Next, we have Janet Edwards. Good morning, ma'am. You were arrested for 1 count of neglect of an elderly or disabled adult and 1 count of battery on a person 65 or older. Ma'am, can you afford to hire an attorney?
No.
I will appoint the public defender's office for you. I'm going to find probable cause. All right, ma'am, you are ordered to stay away from the alleged victim, whose initials are CB. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department, we call a receipt with the court. And in the event the victim moves out, is living somewhere else, you can go back, but if the victim's still in a home, you're gonna have to find somewhere else to stay. And you can only return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, ma'am? All right, thank you. Okay. I don't know. Yeah, obviously.
Judge, I mean, it looks like her mom has some serious issues, Judge, and these are part of the conditions of some of the behaviors of her mom are conditions of mental health issues like dementia or other issues.
Pretrial services,
It overstates objection, Judge. This is abhorrent.
somebody's
It's
raising
like
their
if you,
hand.
she's
on
like
the
this, you
stage.
find a doctor, you find social services, you don't let your mother stay in that.
I know, Miss F, I read it. I know, it's pretty bad.
And this also happens in facilities, Judge.
What?
This happens in facilities, it happens in hospitals.
I understand.
Behaviors
I understand.
come with certain medical conditions and situations.
I understand. She's not in a proper facility. I understand. I don't know who Eduardo is raising her hand, but I'm not promoting you unless I know what case you're here for. So I'll set it on pretrial alternate bond. I'll set it $3,000. Good day, ma'am.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Wednesday. A thank you to Barbara for gifting 5 memberships. Very much appreciate that, and love you too, Barbara. Let's go to Judge Dad's court, because notice who's sitting in the audience waiting to be called. It is Horderman. So let's see what's going on there.
On the Silverlink, right? Yes. Okay, good enough. Thank you very much, sir. Go down the hall, get your notice, then go over to probation, fill out your questionnaire and be interviewed. Thank you. All right, now I'm going to recall Gabriel Keith Montesino's 25B149450, 25B149435A, LaShawn Williams 25B149431, 25B149434A, Nathaniel Lately 25B149362, 25B149241A. All right. Mr. Shemke, your appearance.
Good morning, Your Honor. Christopher Semke appearing on behalf of my client. Mr. Williams.
Charles III.
Nice and loud.
Charles III.
Good morning, Judge Mason Gates, appearing on behalf of Mr. Lake, state for me.
My name is Daniel Joseph.
Attorney Mike Bowler, from Council P, House Council P 65417. On behalf of Mr. Montesino, sir, speech and full.
We are going to do two things. We're going to give them a review hearing date on both of these cases. Lisa, so 12 months out. And then we're going to set up a payment plan for each of them. And by the way, part of the sentence is restitution, if any. Restitution, if any, will be handled through civil litigation. Nobody showed up and made a claim. So restitution, if any, will be handled through civil litigation. Okay. So do you have a date for me on these?
October 7th of 26 at 9 o'clock.
You said October 7th?
Yes.
October 7th, gentlemen, of 2026 at 9 a.m. will be your review hearing date. And if you are compliant, your charge will be dismissed. Both of these will on that date. Do you understand that, Mr. Williams?
Yes, sir.
Do you understand that, Mr. Montesinos? Do you understand that, Mr. Lately?
Yes.
All right, now. I'm simply going to have probation, I think. This case has taken enough time, these cases. You're gonna go down the hall, get your notice. You're gonna go meet with probation. And John, I want you to tell them probation to set up terms of payment on all of these for each one of these kids, okay? So probation will set up your terms of payment. And then I want you to know if you can't make the terms that they set up and you don't have the money, you call the court, we'll go on Zoom or you walk in here on or before a due date at 8:30 and I'll be more than happy to give you an extension, okay? Anything else, Mr. Chemke?
Your Honor, thank you, Judge.
Mr. Williams, anything else? Mr. Gaith?
Nothing else.
Mr. Shemke? I'm sorry, Mr. Baldwin.
Nothing else, Your Honor.
Mr. Montesinos? Mr. Lately? All right, guys, go down the hall, get your notices. Thank you. This has to go with those. Make sure you tell them probation to set up terms of payment. Are these guys ready on this case on Garrett? It says on Zoom. Is Matthew Garrett? Oh.
He's on
Matthew-
Zoom.
He's on Zoom?
Yeah, he's Mr. Shemke's.
Do you have this one taken care of, Mr. Shemke?
I gotta move him. He went in a breakout room.
People against Matthew Garrett. 25W38289. Mr. Garrett, you're gonna have to take your hat off, sir.
Sorry,
Your name?
Matthew Garrett.
Why weren't you here on September 25th?
I live in West Virginia.
Yeah,
I
I
was-
know, but you didn't show up on Zoom either. Why?
I didn't get. I know it's not a good excuse. I didn't get any of the papers sent to my sister's house in Rockwood, but she sent me a Snapchat of the recent paper I just got with this. That's why
Where's
I'm calling
Mr.
now.
Shemke? Mr. Shemke, I need you on this, please.
Good
Your
morning,
name?
Mr. Shemke.
What are we
Here on
doing
behalf
on
of
this
my-
guy? He hasn't paid his fines.
Yes, Judge, he's been out of state. He's apologetic. He wants to make a payment on Friday. And then in the
He's been out
circumstance,
of
Judge.
state since for 5 months, hasn't he?
Yes, Judge, in the circumstance, he'll admit to the violation and is humbly going to ask any leniency when asking for a payment plan.
Mr. Garrett, how much do you make?
I just got my job back. I make about 600 every 2 weeks.
What do you do there?
Subway.
How many hours you work?
I'm working 38 a week. I only
You
make
gotta
10 an
work,
hour.
you gotta work more.
I'm trying to get a second job.
Well, yeah, you should be able to get a second job. I don't like this. You didn't pay anything on this. Nothing. And I told you you should come talk to me, did I not? If you didn't have the money?
You did.
And you were supposed to pay 100 bi-weekly beginning June 9th, right?
I believe so, yes.
Yeah, okay. Well, this is the end of October. You paid
Yes, sir.
nothing. What are you doing?
I just recently got my job back.
Why'd you lose your job? You're fooling around?
No, sir. Actually, I dealing with magistrate court for a landlord tenant, and that's falling through with that. I've been flopping
What?
around trying to get back. I've been trying to get back into housing situations, and I was kind of homeless for a while until I got my job back.
Mr. Garrett,
Yes, sir.
you need to work harder,
Yes, sir.
right?
I
Did
do.
you graduate? Did you graduate?
I have a GED.
All right. Well, you should be able to find better work. Nothing
I'm
wrong
a
with
felon.
Subway, but
No, I'm a felon, so it's hard.
how much can you pay today?
This Friday I can pay 200. That's when I get my check.
You pay $200 by October the 24th.
Yes, sir.
Then $60 bi-weekly.
Yes, sir.
Beginning November 7th. November 10th, I'll make it.
Okay.
If you don't have the money, you call the court, we'll go on Zoom. Don't ignore me again, or I'm not gonna be this nice. We understand one another?
Yes, sir, I do.
Show cause dismissed, Lisa. Thank you. Mr. Garrett,
Thank you. Yes, sir.
grow up. Gotta grow up. Robert Thomas
sir.
Boyd, 25BA 2557.
Real quick before Hoarder Man, that's who this is. Barbara, thank you for the 5.
How you doing, Mr. Boyd?
Hi, sir. How are you?
Not too bad. Your name?
Robert Thomas Boyd.
Are they gonna give me good news when I call them out and they're gonna tell me that you've done what I asked you to do? Or are they gonna tell me, or are they gonna tell me that you haven't done it all of what I asked you to do?
I've got a big dump by the garage. I'm ready to go. I
Ready to go. What do you mean?
get my permit, there tomorrow.
Mr. Boyd? You're not gonna make me put you in jail again, are you?
I hope not.
Well,
I
come
can't get it
on,
done from there.
Mr. Boyd. I can't wait to hear what they're going to tell me. I've been waiting for with bated breath since my recorder told me you were coming in here today. Yesterday, she told me that, oh boy, what has Mr. Boyd done? Or more importantly, what has he not done? Has he done anything? All right, I'll give you a lawyer if you want one. If you want a lawyer, I'm going to give you one right now. Do you want a lawyer?
No, thank you.
Your name,
Caitlin Foley Carter from Fresno Township.
your name.
Rocker someday up at prompt time.
What are you going to tell me? Tell me it's all cleaned up. Tell me it looks like the Taj Mahal. Tell me we'd all want to move in there.
The only progress is that he's gotten a dumpster this week delivered to the site. Nothing
Nice.
inside of the dumpster that I admit that the garage is still.
Oh, Mr. Boyd, you're killing me. You're killing me.
I was waiting till I come in today before putting anything in the dumpster. But
Why?
if you send me to jail for 85 days, I'm gonna send the dumpster back. I can't have it sit there.
Why are you being a wise guy with me?
I'm not, sir. I'm just telling you the truth.
I don't know what to do with it. Short of sending him for 85 days. He's gonna be in there for Christmas. How old are you again?
Part
How old are you again?
78, the 27th of this month.
Well, we share a birthday. Just, you have a couple years on.
Yes, sir.
What am I gonna do?
Your Honor, I don't know what to do. We did have an opportunity this morning to speak to Mr. Boyd. He told us just about the same, that he hasn't done a whole lot since the last time we were here. He hasn't obtained a demolition permit to take down that garage, so
He has or hasn't?
So he made no progress towards doing at least that very first goal. I do have a picture that Mr. Harris took yesterday showing the front of the property that still has the trailer, the boat, the vehicles, what have you.
I don't know why you're making me do this. I don't know why you're making me do this, Mr. Boyd.
I put the boat out in front.
Mr. Boyd, I don't know why you're making me do this. I do not know why you are pushing me to the point that you leave me no choice. I don't understand why you're doing this. I really don't understand it.
I do work slow. I'm 78, you know.
You haven't done anything.
I have. I've done a lot. I've moved a lot of stuff. I had to throw away what I didn't want.
What did you move? What did you move? When did you move it? I don't know that you've done anything.
You wouldn't see it because I put it away.
Can you guys give me something positive here?
Try to start with the positive that he got the dumpster. He has not pulled, nothing that the boat that is for sale, there's not a for sale sign on it. I mean, at least put a for sale sign on it if you're gonna park it in front of yours. Cause he's moved the boat when you were there, it was in the back.
Right.
He moved it to the street.
Nice.
Makes it look worse, but he says it's for sale, but there's not even a for sale sign on it.
How's somebody supposed to be a mind reader? See a boat out there and they think it's for sale without a sign? Don't have anything to be for sale if there's not a for sale sign.
My son promised me that he was gonna put a sign on it. He's half owner in the boat.
I don't know what to do. Do you have any ordinance that allows you guys to go in there and clean it up and put it on his tax rolls?
Short of abating the nuisance civil court, we don't have that.
Short of a what?
Abate the nuisance civil.
In circuit court. I know, but maybe that's the route you need to go.
I was hopeful that this would have put Mr. Boyd on notice, and I understand that doing some time maybe would have jump started the progress, but unfortunately.
I don't know what,
Give me a chance to start tearing it down.
I don't know, Mr. Boyd, come on.
Nice big dump policy.
How long's it been going on, this case, Ms. Foley Carter?
Based on the register of actions, he's had ordinance violations dating back to 2011.
2011, we were young then. You were young, I was young.
This citation was issued back.
That's 14 years ago. Go ahead, I'm sorry.
Sorry, Judge. This citation was issued back in April. Prior to that, he had the civil infraction citation for the same thing.
So you've done nothing. You've done nothing. When were you last in court? Mr. Boyd, I feel horrible. You are a pleasant, likable man, but you are not complying with orders. That's a dangerous building.
Yes, sir.
Forget the blight. It's just flat out dangerous over there. And I can't get you to do anything. I usually would like to think I'm more successful at causing people to understand that they have to do something, and I don't know what to do with you. I really don't. I don't know what I can do. When were you last here? A month ago?
Something like that.
And you've done nothing but move the boat out without a for sale sign and order a dumpster that has nothing in it.
Well, my truck was in the shop for 3 weeks.
Well, good. Then if your truck was in the shop, then you had to be home and you had all kinds of time to do things. I don't know what else to do, guys. I just don't know what else to do. If I saw some effort.
Well, I'll see how well I do with the dump.
New review hearing date in 4 weeks, Lisa.
November 19th at 8:30.
November 19th at 8:30. When I go home tonight, I'm going to feel horrible. But I have to give you another 5 days. I'm setting another review hearing date on November 19th at 8:30.
That doesn't give me.
Mr. Boyd. It's just this the way it's going to go until you take care of the property. You think I feel good about this? I'm not going to argue with you.
Yeah.
I'm not going to argue with you. You're just defiant. I don't know what is going on with you, but I can't allow this to go on. I just can't. This is nothing I want to do. Zero interest in doing what I'm doing right now. None. I'll go home and think about this tonight. Like, what could I have said to Mr. Boyd on the multiple other occasions that he appeared in front of me that might have compelled him to do something?
I feel I have done things.
Mr. Boyd? I'm sorry. Have a seat. I feel horrible. You make me do things I don't want to do. Have a seat over there, sir. Derek Paul Lopez Jr. 25B149536.
Okie dokie. Well, we'll see where that one goes in the future, I suppose. This is going to be like the never-ending struggle with this guy. That's pretty clear. Let's change it up. Let's go to Wisconsin. I believe Judge Mogan is doing a sentencing.
We will go on the record in the matter 23 CF 99, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel, in person with Mr. English in custody. We're set today in this matter for a sentencing hearing after revocation. Mr. English pled guilty to receiving stolen property greater than $10,000, a Class G felony. He was put onto probation in which he was given certain conditions to follow, 2 years of probation with a withheld sentence. He has been revoked off of probation, and he is currently now in front of the court for sentencing after revocation. The court has received and reviewed the Wisconsin Department of Corrections revocation packet and warrant and order request. I did not find anything from my perspective that jumped out to me as any type of material mistake for correction. The court also received as part of that packet the decision from the ALJ, the administrative law judge, in his revocation. Are we in victims' rights compliance?
Yes, Your Honor.
All right, thank you. Mr. Schmidt, argument and sentencing recommendation, please.
Before that, I did receive the packet. I reviewed it. I don't know if this is a correction, but page 2 of the DOC packet indicates where the dates they recommend to use for calculating jail credit. If you use those, you'll get 242 dates. Pages 28 through 29, however, list additional dates that also should be attributed that aren't in page 2. If you use those, the credit should be 262. So I agree with Mr. Chapman. It should be 262 if we include pages 28 and 29.
All right, okay.
And that was the confusion where we were figuring out before court.
All right, thank you. And so, Mr. Chapman, you agree with the 262?
Yes, specifically page 29, I think, was not included in the revocation order and warrant from the Division of Hearings and Appeals.
Okay, and you also confirmed with the either captain or lieutenant of the jail with regards to how many days he has since the packet or their calculation?
I did not. I know he's been in jail since May 27th of this year. My inclusion of, or my calculation of 262 days goes up until today.
Okay. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. Robert English was originally convicted in this case of receiving stolen property. The criminal complaint details that police found property burglarized from nearby places at his residence with his mother in Danbury. The implication in that case was that Kenneth Ochterling was somehow involved in the burglaries, and he was just receiving property he believed was stolen. This is a felony with a maximum penalty of 5 in, 5 out. His only other conviction in Wisconsin is a disorderly conduct in 2022. Minnesota seems to be where most of his convictions are, where most of his life has been. That's where I'm assuming that because that's where the bulk of his criminal history is. He does have multiple convictions there, a felony and misdemeanor for generally either possessing drugs or for lying to the police. He's been extradited from Wisconsin to Minnesota 5 times for either not coming to court in Minnesota or for probation violation warrants. In this case, about a year after being placed on probation, he absconded from probation and once again came in possession of stolen property at his mother's residence in Danbury. He did the exact same thing that the court placed him on probation for a year prior. Both cases are victim cases. Both hurt Burnett County itself. In this case, you could tell from the whole packet, because they send a lot more information now than they used to, that he admitted to the violation of the burglary in Minnesota. He contested other violations in Wisconsin. The ALJ ultimately decided they would only find that with whatever evidence was presented at that hearing, receiving stolen property again, not burglary violations here in Wisconsin. If you're wondering why he likely admitted for the Minnesota one, that involved DNA evidence being found at the scene, so that made it a little different than the Wisconsin ones. The balance sheet shows that for the year he was on probation before absconding, it didn't appear he paid any restitution towards Department of Corrections. Therefore, the victim in 23 CF 99 will have the burden after today to collect on a civil judgment.
And what was that amount?
Oh,
I have it right here. I believe it was $930.
yes, if you scroll to the last page of the DOC packet, it was $930 for restitution. If you add in all the other costs, it's $1,541. And that's where I made the determination that nothing had been paid on it. So at a probation revocation hearing such as this one, the court's supposed to do the sentence it would have done back at the time Mr. English was originally sentenced. However, it can also consider his behavior on probation that can modify what the sentence can do. So in other words, conduct on probation could result in a worse sentence based upon how probation went. Robert English is 40 years old, meaning he doesn't have a young developing brain, but he's also not in the age range where we'd say they're, aging out of crime. His history actually shows like a ratcheting up of crime as he's entered middle age. He has a past history of crimes. However, they're just drugs and lying to the police. They are not really for stealing. This was his first conviction for something like that. So this is obviously not a max 5 in, 5 out sentence. He doesn't have a history of criminal convictions related to stealing that would, I think, be necessary to justify that kind of sentence. DOC recommends a 1-year jail sentence, which he's like I'm bad at math, less than 2 weeks away from a time served sentence on. I don't think this is a 1-year jail sentence. I do think that if Mr. Robert came before the court in 2023 at the original sentencing and said, I don't want to do probation, I don't think I can do it, I think there's a chance the court might have done something like a 1-year probation sentence. I suspect the court might have required upfront restitution for that, but I don't know for certain. But instead, Mr. English convinced the court to give him a chance. And the court took a chance when it placed him on probation. It even gave him the ability to discharge early from probation if he paid the restitution off and had no violations, which I took to mean from the original sentence. The court, probably because of the lack of history of theft convictions, gave Mr. English a chance, wanted to believe in him that he'd want to make things whole, make amends. I think for that reason, the fact that Mr. English did not pay back restitution, he stopped reporting to probation. DOC, the way ALJs used to handle abscondings, they used to say that strikes to the heart of probation. You can't be on probation if you're not being monitored. You're just not getting punished then. And because according to the sentence after revocation packet, with the admission of the burglary in Minnesota, that's an escalation. And with the finding of the receiving stolen property is one of the other violations they found. And just the fact pattern. He got placed on probation for receiving stolen property, having stolen property at his mother's house in Danbury involved with Kenneth Ochterling. And the violations are the exact same behavior. It's really bad when a person placed on probation while they were supposed to be on probation absconds and then does the same thing. That, I think, escalates it beyond the 1-year sentence. It's still not, a max prison sentence. I do think that some prison is necessary here because of how bad probation went in this case. With the information of the progression of probation, I would recommend something more than 1-year county jail. I would recommend a half sentence of 5 years where the breakup would be 2 years initial confinement, 3 years extended supervision. So that would still be half the total exposure. And then it'd be weighted toward the ES, meaning he's doing less than half of the initial confinement he could do and a little more than half of the ES. Well, I mean, the court could do a lot more ES. I think that sentence is necessarily to not depreciate the seriousness of the offense and also the behavior on probation. I also think that such a sentence is necessary because it'd be a terrible message in terms of specific deterrence and general deterrence to the public if a person can, look at probation as just like a gamble. If I don't get caught and keep trucking forward with the same criminal behavior, then maybe I'll just avoid a jail sentence at all. And that shouldn't be how probation should be viewed. It's a privilege for a person to be placed on probation. It shouldn't be viewed as a gamble. It should be viewed as the court taking a chance because there's good belief that a person's going to correct their behavior. They're going to make amends to any victims. And when we don't see that happen, it needs to be viewed as aggravating. We need to take that into account in the total sentence. So that's what I'm asking the court to do. Thank you.
Thank you. Mr. Chapman?
Judge, I want to clarify one thing. There was no burglary in Minnesota. The state repeatedly referred to the burglary in Minnesota and said it was different because Mr. English's DNA was found, so that's why he admitted to it. It was also different in nothing was stolen. This was an abandoned building in Minnesota that Mr. English was squatting in for a period of time. He left things there, like I believe a candle and some plates and empty food cans, but there was nothing stolen from there, and no evidence indicated that anyone was living there or how long it had been, quote unquote, broken into. So yes, that was completely different than the other alleged burglaries, the ones that were not proven. And the state says, well, based on whatever evidence was presented, you can see what evidence was presented. It's all in the packet. It's the same reports the state is using for its criminal complaints, which I believe the court already dismissed once, and then it came back after an amendment. I would agree that the behavior appears similar to the original complaint in 23 CF 99 in the sense that he's still associating with Kenneth Achterling. That's his fiance's brother. Looks like in the original criminal complaint, I had nothing to do with that case. I've just read the complaint, but it looks like Kevin Achterling brought these UTVs around and Mr. English was riding on one and had the key in his pocket. Maybe the state thinks Mr. English stole them, but the plea was to possession of stolen property, and the indication in the complaint is that looks like Kenneth took it. Similar behavior in this case. It sure looks like Kenneth was taking stuff and stashing them at Mr. English's mother's house because he also has connections to that residence. As you can clearly see in the packet, Mr. Achterling was the one who was over there fixing, I believe it was the, was it the well? I think it was the well that he was over there fixing for her, and he was using stolen parts to install a well. The ALJ did not find that Mr. English was involved in any of the burglaries, and he was revoked for absconding. Perfectly justifiable. He absconded. He was homeless for a very long time. Mr. Achterling tells me that the last stable residence he's had was with his father 7 years ago. He doesn't get along with his mother. He can't live with her. He stops by there occasionally, but he doesn't live with his mother. He's been using methamphetamine for a very long time. Homelessness is probably connected to that. I know the criminal history in Minnesota is all connected to that, but his criminal history in Wisconsin consists of this case, 2 UTVs that were stolen the night before found at his residence, and now the fact that he's been revoked and charged with other stuff that is currently set for trial. Given the criminal history is all drug related, not in any way related to stolen property, finding 2 ATVs the next morning at his house, yes, it's a Class F felony because the ATVs were worth more than $10,000, but it could have also easily been operating a motor vehicle without owner's consent. I don't think this is an aggravated version of receiving stolen property, and I don't think it calls for prison. I wish there was an option to put him back on supervision. I agree with the state that probation was essentially a waste of time here. I think Mr. English tried, but he didn't have a house, he didn't have a job, and he was addicted to meth. Probation, I think, was likely doomed to fail from the start. But I don't think that's an aggravating circumstances that makes the sentence now call for prison. Yes, he will be released soon if the court follows the DOC recommendation, but that's because he's been in jail for a very long time without any release privileges and essentially sitting 100% of his time in the county jail. I think the DOC's recommendation is appropriate. I would ask the court to follow it.
All right, thank you. Mr. English, is there anything that you would like me to know? Do you want to make any kind of statement today? You do not have to, but it's your only opportunity.
I would just like to admit, like, yeah, I did a scholarship. I didn't have a phone all the time, so I couldn't call. And I don't have a driver's license or a car. So it'd be hard for me to get from Mayfield, Minnesota, all the way up here to check in. And when I did get out of jail last time, I called my PO up here and told her I will try to get up here the hardest. We did have a vehicle, except it wasn't reliable. It needed a back bearing and the rear tire. And so it wasn't safe to drive up here. And I kept telling her that I'll keep trying to find a ride if I don't have people that I can rely on really for that stuff. I did try. I did try my hardest, and yes, I do suffer from mental disabilities that I do want to get fixed. I wish you guys had mental health stuff here to help me. And with that, I'll just let you guys know I did try my hardest. I did. Instead of not having, like, I did try to live with my mom. And last time I was up here, a dude pointed a gun at me and told me to leave my mom's house for good. And I was like, all right, whatever. I just grabbed my dog and left.
Okay. So you're basically just giving me excuses as to why you couldn't get to probation?
No, I'm just,
That's accurate.
yeah, that's accurate.
Accurate.
Yeah.
Explanations.
Yeah. I'm sorry for my behavior.
I hear excuses, not explanations. There's a difference.
Yeah.
Anything else you want me to know?
No, that's it, Your Honor.
I have reviewed the revocation order and warrant packet, and I've heard arguments from both attorneys, and now I've heard your statement, Mr. English, as to why you weren't able to, in your words, weren't able to go to probation, and you absconded for a period of a year. Mr. Schmidt alluded to, or he stated, the court probably at your sentencing.
Mm-hmm.
And he was pretty much spot on, because I remember your sentencing very clearly.
Yep.
I remember when you were arrested on this or taken into custody with this matter very clearly. I remember having discussions with you very clearly in my brain, in what I remember about that date and time and around that circumstances, the circumstances of this case, as well as at the time of sentencing. I remember very clearly that you told me that you were in a better position and that you were going to remain sober. And that was what you were looking at. I remember very clearly, you told me at the time that you then you had become a father.
Miscarriage.
What?
She had a miscarriage.
She had a miscarriage,
Yeah.
but you were going
Yeah.
to be a father.
Yeah.
And you were changing your life around completely because of, not only because you were becoming a father, but you realized at that time you were done with this criminal life. I remember that very
Yeah.
clearly. Am I remembering incorrectly?
You remember that correctly.
I'm remembering all of it very correctly. And Mr. Schmidt, when he said the court probably, most likely the court did this, probably because of this, he wasn't even here.
Yeah.
He didn't even argue that sentencing. And I don't know, and I don't know, maybe he read a transcript, but he was spot on with guessing what the court probably was thinking at that time. And those were all the things that I was thinking at that time. Because quite honestly, at that time, based upon the history that was recited to me with regards to your criminal history from the state, even acknowledged by your attorney, Mr. McLaughlin, at the time, and by you at the time, because I had seen you for that disorderly conduct not too far in the past from this case. It was serious. You acknowledged and you admitted with those ATVs and having that property, which wasn't yours, and then telling the court that you were going to change your ways and change your life, and you wanted to make it whole with the owner of those ATVs.
Yeah. I still do.
I know you still do. And that's great, grand, and wonderful.
Yeah.
Okay, great, grand, and wonderful. But we're talking about August 7th, 2023. August 7th, 2023 is when I sentenced you
Yeah.
originally for this. And that's when you told me all of these grandiose ideas and thoughts that you were having about changing your life, getting back on track, and making the victim whole. Because I believe, if I'm recalling correctly, the court discussed, or we talked about how in Burnett County, this is what's happening, or this is something that happens. And you're saying yes, and you're nodding your head, because that is what happens in Burnett County, we're a vacation spot where our population triples or quadruples in the summertime or in the nice vacation times. And then it goes back to our normal population in the cold times because people close up their cabins, they close up their things, and that's where they become a target. In sentencing, you've been here before in front of me, and now you're here again. You've been in Minnesota multiple times for other things, and you've been on probation. The court has to look at how serious is this, all right? It's serious in the fact that it has taken somebody's trust away. Granted, you weren't the one that went in and took the property or did the things. You had admitted to receiving that stolen property. And you had admitted in that complaint that most likely it's probably Mr. Achterling, or you mentioned Ken and those things. But you admitted to receiving those ATVs, either for converting them to your personal use or selling them for a financial gain or some other thing like that, or to give to somebody and, be a hero. And here's your UTV, I guess, not an ATV, a UTV. I have to look at you and your record, your criminal record. I have to look at you where you are today. I have to look at you and how you were on probation when I gave you that chance.
Yeah.
I said, here you go. Here it is on a silver platter for you to better yourself, to better your life, to be that person. And I understand, and I'm getting where you're probably saying with that miscarriage, that caused some issues emotionally for you and for your girlfriend. And then it caused you to spiral and then yada, yada, yada. That's what I'm going to believe. And you're nodding your head up and down. You're saying yes, that is.
It was very devastating when I got on and she said she had a miscarriage. It was very devastating for me.
And I understand that, Mr. English. I do. I also understand that there are many, many people that come in to this court. They sit in that chair. They're sitting in orange, and that they have been through the same or similar, that they have substance abuse issues and all of those things, and they don't turn to this type of crime. It's usually just the possession of methamphetamine or the other drug-related things. But yet this is something where you're taking from somebody else. Even if you're not the perpetrator who goes in and breaks into that building or shed or whatnot, takes those UTVs, you may not be that person, and that's not what you pled guilty to. That's not what you admitted to, but you admitted to receiving that property, knowing full well it was stolen. Full well it was stolen. And you wanted to convert that to whatever use you wanted to do. I have to look at needing to protect the public, and that is the community of Burnett as a whole. Here, there may be a single victim, correct. However, with looking at protecting the public, I have to look at deterrence, not only general deterrence of specific deterrence of deterring you from doing this again, because slap on the wrist. It has to be more than a slap on the wrist, apparently, for you to understand this is not something to engage in. This is not something that you can do. And general deterrence to deter others from doing the same thing. Because again, we are a tourist county. We are where people come to vacation. They come to have their great and joyful, wonderful life. They live on the lakes. They use our woods. They hunt, they fish, they hike, they swim, they boat, they do all of those things. They come here for solitude. They come here to feel stress-free and away from their other grind of wherever they live. And the general deterrence is a sense for general deterrence is to say, hey, they deserve to have that peace. They deserve to have that solitude to come here. They deserve to not have to worry about their property when they're not physically there, because they have worked blood, sweat, tears in order to pay for what they have here. If this continues, and there's no deterrence, then Burnett County loses revenue. We don't have tourists. We don't have people that want to come in here, because if it's a scary place and all your stuff gets stolen and somebody else has it, again, even if you're not the one who physically went in and took that property, even if this property was something that was stolen from Minnesota or brought here or vice versa, people don't deserve to have that fear of not having their property. Looking at your probationary period, and yes, it is correct. For the most part, the court looks at what the court would have done or would have sentenced at the time of the original sentence. But I also do have to look at what you did on probation, which was nothing, not one thing. You absconded for a year or so. You didn't even pay $1 of restitution, not $1.
It's hard when you can't get a job.
Whose fault is that?
Mine, I tried, and I got a job at the end before I got arrested.
Great, grand, wonderful.
Yep.
Again, great, grand, and wonderful. Hard to get a job. But again, you were given an opportunity and you didn't just blow it. You blew it, you missiled it, you threw some bombs on it, you did all the stuff and you said, doesn't matter. Because even if you couldn't get a job, you still could report to probation. You could still work with your probation officer, and you didn't even do that. So I do think that here today, it is more serious than what it may appear to be. But it does appear to be serious anyway. The receiving of stolen property, that is serious. So I do believe that this is a prison sentence. I'm going to sentence you to 2 years of initial confinement with 2 years of extended supervision. While you're on extended supervision, you will absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug testing. You will do some type of thinking for a change or breaking barriers. You will have no contact with anyone on felony probation or felony extended supervision without your agent's approval. And yes, that does include your brother-in-law and your girlfriend and any other person without your agent's approval. Anyone on felony probation or extended supervision, and in particular those related to illegal substance use and or any type of burglary or receiving stolen property or theft, those types of things. Gainful employment. And I'm going to go back to that gainful employment. There's plenty of ways that you can get a job because we have the Ruth House up in Superior. People go there all the time, multiple felonies, and they still find a job. They still work. They still work on their sobriety. They do that.
I was thinking about that while I was in here.
Well, now you have time to think because the Ruth House can give you a job. It can help you find a job. And I have people who have not had jobs in over 15 years that go to the Ruth House, that they have a job and they say, Judge, I have a job. I'm paying my way. I have an apartment now. I am sober. I've been sober for 200 days. I'm doing this. There are options and there are alternatives than absconding and not doing what you are legally required to do. There are options. So after gainful employment, I said the regular drug testing. With regards to the early release programming, you are eligible for early release programming for the substance abuse. I think you are beyond the age for the challenge incarceration. You must pay your restitution. That is part of your extended supervision. You must pay your restitution, and your restitution will be paid, must be paid by the end of your extended supervision. $100 a month when you are released from custody. When you are in custody, I'm ordering that the court costs and fees and the restitution can be collected by the Department of Corrections at what they determine to be reasonable while you are in state prison, and that is a condition of your extended supervision. DOC shall collect your sums. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. We have your DNA. Anything that you fail to pay means that the court will enter a civil judgment against you because you're always going to owe it. Plus, I could issue a warrant and you could sit up to 6 months in jail. Very important that you pay and you pay timely. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman?
262 days credit, please.
Thank you. 262 days of jail credit. We are adjourned.
Come talk to you down there.
Okie dokie, Judge, not messing around with that one too much. I'm all right with that. Just an FYI, yesterday we went about a half an hour long on this show, and we were long because of a hearing in front of Judge Wolf from Tennessee, and that hearing ended in a recess that dragged on for a long time, so we weren't able to finish it. I do have the conclusion of that queued up. We will probably go there somewhere around the top of the 3rd hour, so stay tuned for that if you want to see how that finishes up from yesterday. But for now, let's go to Texas, and we will say good morning to Judge Stevens.
You're looking at a burglary of a habitation. You're on probation. That's up to 20 years in prison. I'd be here early.
Yes, sir.
I know if it were me.
It was just true.
There's a second amended motion to revoke probation that's been filed that has added several things this court is not real happy about. You're on my watch, on my probation terms, and I've got a motion to revoke probation that is alleging 11 separate grounds of violations. Do you understand?
Yes, sir.
The last 3 here, failing to complete the drug intervention program. And because is that important? Well, the next ground is you're providing urine samples through the probation office when we test you, and you're getting tested positive for synthetic marijuana on my watch.
No, sir.
Yeah, oh, yes, you did.
It was marijuana.
It was synthetic marijuana.
I thought it was THC, sir. It was just.
That's why
I'm
you're
sorry.
not the expert.
Yes, sir.
Okay. Synthetic marijuana on my watch? Are you kidding me?
I didn't.
You know, that's,
Sir, can I explain?
no. You will have a fair chance to explain.
Yes, sir.
There is no way I should be taking bodily fluids and testing them, and you test criminal actions. That's a crime. To possess this is a crime. When it's in your system, it's possessing it. You don't have to have it in your pocket. If I test you, like I'm allowed to test you any dadgum time I want, this is what happens. We find this too often. People make promises when they said, oh, I'll be on probation. I swear I will follow the terms and conditions of probation, but you did. You made that swearing. And I've got 11 separate grounds I'm looking at where you have violated probation. You see anything wrong with that? 20 years in prison. Does that strike you as serious?
Yes, sir.
It does?
Yes, sir.
You shouldn't even be spitting on the sidewalk illegally. I mean, if it were me, but well, this thing has gone on. Looks like you made some pleas of true last December to illegally possessing MDM. See, these are drugs. Once again, that's synthetic marijuana was what you pleaded true to last year. And then now you've got the completed the first of the yes. So we hadn't dealt with it. The first amended. So we've got 8 is committing the offense of aggravated robbery.
That was refused, Judge. That, we took care of that. I think it was dismissed, so we got rid of that. That's been abandoned.
All right. Then second amended is failing to complete the drug JCDI, providing a urine sample that showed positive for synthetic marijuana, failing to submit to alcohol and or drug screening. What happened on that?
Your Honor, while he was in the JCI orientation, he had a color code and he was called on March 3rd and March 5th and reported.
He refused to come in?
No, sir.
I'm sorry. I was asking this man, Mr. Rude.
Yes, sir.
You don't follow any rules, do you?
Yes, sir.
You don't follow rules of decorum, of proper behavior, of not committing crimes, of probation orders. I can see it didn't take me long. I know what you are. You like to control your environment. You're the boss. It's on your terms. Not anymore. Go ahead. While you were rudely interrupted, I want you to proceed. Thank you, sir.
Yeah, during the color code, he, according to the records, he failed to show up on March 3rd, 2025 and March 5th, 2025 with the color call.
Okay. I've got this second amended alleges 11 separate grounds. Now, we dealt with a couple of them already, but I didn't think I'd ever see you again. I thought you learned your lesson.
Glad to see you again, Honor.
You're glad to see me?
You said I didn't plan to see you again, Your Honor.
Well, science got you. The testing got you. But it's your choices that are being made. All right. I've railed on him. It's time. And here's why I'm upset about it. Because you got a 93% success rate. Only 1 in 14 probationers failed. I wanted 100%. I want everybody to succeed. That's why I'm disappointed. Because you made promises to me when we put you on probation. Promise to follow. Yeah, I do. Don't worry about it. I've got 11 separate reasons you didn't. Well, if it were me, 20 years in prison would be enough for me. I wouldn't have to have a judge rail on me about, hey, this could happen and make sure you do well. You wouldn't even have to tell me that. I'd be way ahead of the ball game. I'd be making sure I came to probation 30 minutes early, and I ran like the wind if I even sniffed a drug around me, and et cetera, et cetera. What are we going to do today?
I don't know.
Well, it's
Judge, if we recommended he go back to JCDI, he couldn't complete it because his probation would have expired, and so the only option is penitentiary time is what I've offered him. Just minimum penitentiary time, but I have offered him pen time.
Or could we consult with probation and see if there's possibly any other ideas to get Mr.
How much time does he have for it, please?
Finish line.
You see, pre-sentence report.
Yes, sir.
It would be so kind. And thank you very much.
That's big. Speech.
649 days.
How much?
649.
Thank you.
649.
On Restitution was 1,040. Did that get paid?
Yes, sir. No, he paid it all off.
Yes, sir. Almost is.
Is that your phone? Whose phone is that?
That was mine, Your Honor.
Turn it off.
Sorry.
Okay. What are we suggesting here today?
I'll give 2 years spend time,
What?
2 years spend time. Leave him in there for a little bit and pin so he can see what it's like.
He probably wouldn't stay long.
No,
How much? Yeah, 600 days.
649.
but he's done over 9 years probation and so
And he does have a little under 4 months left on probation, Your Honor.
That's,
and
yeah,
I
this is terrible.
understand.
It's a crime. And
Is it possible?
we've dealt with him. This is, if it wouldn't be a second amended. I mean, we've got 3 motions, 3 times he's made mistakes. I open the door and I go, I want the Khalil Robinson rule, please. I open the door for one. It's what's fair for one is fair for all. Look, this is my 3rd or 4th time, but Khalil had 3 separate, well, 4 counting being placed on probation. Then he's got a motion, then a first amended motion, and then a second amended motion, and you let him go. And that's me too. But can I have Mr. Robinson's rule? You are fair, aren't you, Judge? How do I answer that? And of all things, this is a serious crime. I don't know what got into you to synthetic marijuana. Give me a break. We're gonna catch you at that.
sir, can I speak my piece?
Yeah. What are we gonna do first? And then you have an opportunity to be heard.
sir.
I know you like to control things.
No, sir.
Yes, you do. Yes, you do. I mean, it reeks. But you're on probation. You gotta, here's what's ironic. You're violating the same rules I have to follow. And I follow them. And I'm not worried about going to prison. You ought to be. Any one rule, but when you commit a crime, that's a serious crime.
Yeah.
Go ahead.
Yes, Your Honor, if I may.
Yes, ma'am.
Despite Mr. Robinson, I know he never obviously got started with JCDI. There are classes that he has continued to attend. I believe he did provide the attendance records. In addition.
What did he learn? Because once again, just because you go to JCDI and you didn't finish it, that's not enough for me. You have terms that you've been required to follow since 2016, and you're going to interrupt me?
No, sir.
Do I have to put you in timeout?
No, sir.
I mean, that's what we're acting like, a little child. You're going to have a chance to be heard, but you're looking at 20 years in prison.
Yes, sir.
I'd be polite if it were me. Go ahead.
Yes, sir. In addition, Khalil has completed all community service and current on fees and paid restitution. Your Honor, he's just so close to the finish line, and I would hate to, obviously, someone to have a conviction on their record, but I understand.
No, but if it was the first one, he's got 11 violations on it.
Would the court consider a sanction?
Oh. But that is the minimum. And he'd probably get out. Realistically, he'd probably check in and be checked out. But after the 3 separate motions filed, we've got I can't open the door. He had to have learned his lesson by now, or else this is treacherous territory for me. Because I try to be fair, and I get called on this one. They say, I want the Khalil rule. And I go, well, I do try to be fair, and how do I answer that? I mean, we're 11 violations here this time. Anything else? You know what? Yeah, here's what we'll do. Let's just have a hearing on it, and then I'll make the decision. If he had an offer, y'all don't want it, sit over there though before you leave, and we'll just have a hearing. That's what we'll do. And I'm not bound to 2 years. Okay, can I get drug test? We're gonna have a hearing, your bond is, we got some problems here, but when can y'all be ready?
It's administrative, we'll be ready week or two. We're going to do a couple weeks. Yeah.
Okay. All right. Y'all can't work this out, then it's up to me, and I'm not looking at 2. All right. So, got Cameron Smith. Reagan? Hello. Okay. What are we gonna do?
Judge, I have a new offer that I received this morning. I need to review it with my client.
How much time do you need?
3 weeks to do that.
You got 2.
That's fine.
What are we gonna do? What's the plan? What was offered?
There's a new,
5 years probation with a conviction.
What's the injuries status on this?
They've been treated.
And
there was nothing more than some bruising, at least from my interpretation of the medical records. There was no fractures, no dislocations, nothing like that.
I do not have anything, but I will check between now and then to see if there's any restitution, but I haven't been sent any. I'll check with the complainant.
Yeah, these are, as we know, what juries have done lately on these. They don't like it.
Yes, sir.
You don't have a wreck with somebody and then leave. Whether it's your fault or not, the law states if you're involved in an accident, you have a duty under the law to stay and try to help treat anyone and get help for anyone who might be injured. Even if it's not your fault, you leave, the jury's convict here. They don't like it. I don't like it. I don't think any of us like it. It's just humanity. It's humane. It's one of the most humane laws that have been instituted by the legislature. And it's a shame humans have to be ordered and be subject to up to 10 years in prison for not doing something like that. I mean, that's just humane. It's just a decent thing to do. You're in a wreck, you help people until the ambulances get there.
And just since the injuries were not major, this is one of those hybrids that it's only up to 5 years and there's misdemeanor punishment possible. So.
Right. Okay. How much time?
2 weeks.
You got it.
Thanks, Judge.
Yes, ma'am. Brent?
Where do you want to go talk to some clients, Sean?
Cullen Cannon, are you here, Cullen Cannon?
Cullen Cannon? Special counsel.
Here they come. And from probation? Hey, Brian. Cullen Cannon.
Morning, Judge.
Is this Cullen?
He is.
Cannon, we have 2 cases here.
Yeah, she'll get.
2 aggravated assaults with a deadly weapon, huh? Is this the same event?
Yes.
Looks like
Same
two victims out of the same event? You are Cullen Rayford Cannon? I'm asking you a question?
Yes, sir.
Okay. In 25 CR 398 and 399, do you understand, sir, you were charged with the second degree felonies of aggravated assault with a deadly weapon which carried with it, would generally carry with it up to 20 years in prison. But because it is alleged you have a prior aggravated possession of drugs in 2022, which occurred before you committed this offense, then that second degree felony punishment would be increased to a first degree felony if it's true. And so you were looking at then no less than 5, no more than 99 years confinement in prison or life imprisonment and a fine up to $10,000. You understand?
Yes, sir.
On each case,
Well,
Yes.
which under the law could be stacked. What are you gonna do today?
Judge, the state has made an offer, trying to explain the offer and how it in grand sum works with some other aspects of the auto insurance bit. Mr. Cullen was trying to grasp that, albeit admittedly complicated bit of how restitution could be covered by auto insurance. I'm trying to explain that to him right now, so that maybe we could get to that offer and be with these cases. But he's,
Well, that's not gonna be something, I mean, the insurance company's gonna have a say in it, won't they?
yeah, well, yes, Judge, but I'm explaining the process to him. So
I think we have an amount, Your Honor, that's owed, that we've given him. I think the issue is gonna be whether his insurance covered that or not, but, I think we've given him that number, we've given him an offer, and, I think that's where it's
But
at.
he ought to know what limits are. We all,
he doesn't understand the process, the legal processes. I'm trying to explain to him.
what's the amount of restitution?
$30,000.
Generally.
Yeah.
Yeah, do you have good insurance? As far as you know, who's the company?
It was Mile Auto at the time.
Never heard of it. Mile Auto?
Mile, like mile high, mile auto.
Oh, Mile Auto.
And I'm explaining how the two things can work together, but it's, as the court knows, a little more complicated than the typical, we're just gonna cut a check out of my check.
Well, once again, they make a review and.
Yes. Oh, yeah, and that's what I was explaining to him, so.
Yeah, if you don't have it since years, I'm going to look at the United County.
There they go.
This one you have the case though.
If the
What we do today?
If I get it, I mean, I'm trying to explain to him, I think we can get this done. Can we reset
Today?
1 week? Yeah, I think I will be.
No, you want a week?
Yes, sir.
You got it.
Okay, there you go. Thanks, Judge.
Anything else we need on bonds or anything like this?
No, Your Honor.
He's been compliant. He's been in touch with me.
So what's the plan? Where we're headed?
He, 10 deferred on, both the cases, Your Honor.
With
That's,
restitution.
With
I'll
restitution.
explain-
And I've spoken with the, victims on this, and that's what they were, agreeable. That's what they were wanting. They did want the restitution back, so that was part of.
After the review, if it
Well,
do I still have use?
Line and judgments.
but if he has insurance, they can get it back.
Yes, sir. That's what I'm explaining.
I mean, whether y'all want it or not.
Yes, sir.
Want to do something.
I was explaining that
The side deal on the civil.
practical benefits, so that he understands what can be happening. So as it relates to this offer.
Let me ask. It sounds like the state's concerned about restitution, which they always should be.
Yes,
The victims. What can you do about figuring out how soon restitution can be paid
Well,
from the insurance? Can you get with them and find out?
Well, the truth of the matter is, Judge, is if he pleads guilty to this and he takes the
I
offer.
know, I just want to know.
Then the judgment from this, just from the judgment alone from this court, he can, the complaining witnesses can then take that judgment to their insurance, the insurance company, and that should facilitate everything. Because the burden on her is higher.
I want the victims though, not to have to do legwork. I want them to do, I want y'all to help.
Well, he could turn it
as
in.
much. You're representing him and this court's concerned about victims being taken care of. So y'all do what you can to facilitate these people getting reimbursement back as soon as possible. That's going to be part of a deal that I would accept, not otherwise. It's just decent. It's a decent thing to do. And you know how that can bog down.
But I mean, like you said, the insurance is going to get a vote, but I think with the judgment, it should expedite matters. So
Can you get with them and find out what?
I'll visit with you, Judge. This is me explaining him the civil part of this is relatively new to him, and that's hence the confusion, because it's not as straightforward as typical. So, 1 week, Judge?
Yes, thank you. I got, John Landry. That looks like that should be set.
Oh, here, sorry.
Where's John West?
He's working on some plea papers, Judge.
What's again? Oh, by this, sorry. It just, it's the new seven. Did you know the date is here? This.
How you doing? Morning. So, are you gonna be full report? How? She's great. What are you doing? You can't.
No, that's not fast. Anything not doing it is just. So saying she keeps up.
All right, they've gone into random chat mode there. Let's change it up. We'll go to Michigan. Judge Oakley.
Looking to discuss review options. People in my I have reached an agreement where the original charge of stalking would be dismissed and the malicious use of telecom will be entered. There is a recommendation, Your Honor, for a 12-month period of HIDA. Respectfully, Your Honor, we're asking the court to depart from that just slightly. What we're asking for in this instance will be a 6-month period of HIDA. As I originally.
Stop. Who prosecuted this? Okay, you're here. Okay, go ahead.
Your Honor, that's the recommendation. We understand where they're coming from, but we would ask you simply that the court adopt a 6-month period of HIDA probation. Reason being a couple.
Hold on, who's that guy?
Your Honor, he's a stranger to this court.
Good to see you in person. Yeah.
Your Honor,
Go ahead.
do not take it out on me with this client because my co-counsel's presence.
Go ahead.
Your Honor, if I can think of an individual who would be a great candidate for a little bit of a break from the court, it would be this individual. This case has been pre-tried extensively. There's been multiple adjournments. Throughout this whole period of time, my client hasn't had one single bond violation or allegation. He's done that despite the fact that he's presented me with evidence of the complainant reaching out, and I don't want to call it extortion, but essentially saying, come on, let's get back to child support, let's get back to a parenting agreement, we can make this case go a different direction. He resisted the urge and did the right thing all the way through. He's shown maturity, he's shown responsibility, he's thinking about his kid first. I understand that the people have their positions to the 12 months. I would say they've got a long road ahead of them in the Third Circuit family courts. There's paternity to sort out as far as getting.
How old's kid?
Health child.
Oh, baby. Go ahead.
So you see kind of where we're going with this, which is everything that would be a normal recommendation would ask the court to adopt. And just instead of having this 12-month where that can be basically fodder for what would look like possible custody issues down the road, we give him the opportunity to do what I would say he's already kind of done 6 months on probation because he hasn't screwed up in any way, resisted the urge to respond, to defend himself in text message or through family members. There's no criminal history, no conviction from the young man's record. He's a long haul truck driver, so he's often away from Michigan for pretty extended periods at a time. For all of those reasons, we think he would be a good candidate for a downward departure if this court would entertain us on this.
Okay. Who do you work for? How long you been with them? Okay. How long you been trucking? Okay. All right.
So kind of the beginning of a fledgling career.
Yeah. Any priors? Okay.
Yes.
I'm inclined to do a PSI. Do you think we need a PSI?
I think the victim is here today, but if we're talking about attorneys, willing to leave it to the court's discretion. Yes.
Yeah, let's do a full-blown PSI, and then I'm more likely to listen to your deviation request.
Understood. So what he's saying is you have to meet probation, you have to and the license for the recommendations and prevent the next 6 months while I'm still the probation.
So let's get to the plea. Did you discuss your rights and options with Mr. Hadley? Your rights and options.
Yeah.
You understand all that? You understand the possible penalty for the malicious use of a telephone device? Understanding all that, are you pleading guilty to that charge today? Are you doing so freely and voluntarily? Would you voir dire, Mr. Hadley? I've got an incident date shown June 25 this year.
June 25 of 2025, were you present in the county of Wayne? I want to say this was Township.
Romulus.
City of Romulus, County of Wayne, State of Michigan. Yep. Okay. By that date and time, you sent some text messages to the female that you had a child in common with. Yeah. Okay. And some of those messages, did you make insulting or harassing statements? Yeah. Okay. And actually, I would say I think we're pretty well satisfied.
I think that does. Mr. Lucky, you satisfied? All right, I'll accept the plea to the added charge, dismiss the original. I'll continue the bond. I'm going to send you downstairs. Just go up to the counter. They'll schedule for you to come back and meet with one of the probation officers. They'll put together a report and recommendation. You'll have a chance to go over it with Mr. Hadley. I'll see it. The three of us will have some more conversation. I'll decide what the sentence should be. Understood? No, unfortunately, it won't all be today. Yeah, but we'll try to schedule around you. We don't want to cause you to lose your job. All right?
Judge, so that was malicious use of telecommunication?
Telecommunication device, correct.
Thank you.
Latanya Seabury.
Yes. Hold on. I am trying to get back.
Is Miss Walred in the courtroom?
She
Oh,
is.
there she is. Thank you.
Go ahead, counsel, your appearance.
Good morning, Madam President. 85665 on behalf of Ms. Latanya Seabury, who appears by way of Zoom. I think that her audio is working, but I'm not sure if she's able to turn on the camera. Ms. Seabury, can you state your name for the court? You did now, you might have to look at it again.
She had both on earlier, but there she is. And now unmute. Yep, very good.
Miss Seabury, just say your name for me.
Yes, hold on. What happened to the video?
You're fine. Just say your name.
Latanya Seabury.
Thank you. Counsel, I can't read this. It says something pretrial stage.
We are just asking you to set for a preliminary examination, I think.
Okay. Okay. All right. Heather, what are our exam dates?
November 26th or December 3rd?
Hear those, counsel?
Unfortunately, yes. November 26th, I am available. That date would work.
Okay. Heather, you want to do it at noon?
12:30.
12:30? All right, Miss Seabury, November 26th, 12:30, live my courtroom. Understood?
Yes, sir.
All right. Counsel, bond continued.
Thank you.
Have a good day, Miss Seabury.
Good, Jack. Did you run those back?
Counsel, anything else ready?
I have Miss Shimmery and then I have Miss Hester, who I think is having a breakout.
Miss Shimmery, activate your camera. Same date.
Thank you. Miss Shimmery, are you able to take you?
Miss Shimmery, can you hear me?
Yes, I can. Can you see me?
I can, thank you. How about November 26th, 12:30 for your exam date?
I can make that happen. Yes.
Bond is continued. We'll mail you a notice. We've also got some stuff here. A disorderly person from Van Buren Township. Looks like you owe $354. We haven't seen any money since July. Can you get back on track with some kind of regular payments?
I'm trying with everything going on. I'm really trying. Yes, I will get back on track.
If you want to talk about options on how you can resolve this without $354, it's easier to do it in person, but come in here and talk to Community Enrichment. That's Mr. Taylor, and he'll tell you what some options are that could be some time to help close this out with some charity work or something.
Thank you. I
All right.
appreciate it. Thank
You're
you.
welcome. And counsel, who was the other one? Hester. And Miss Hester, you can hear me all right?
Yes, sir.
Thank you. Counsel, your parent for Miss Hester.
Ms. Crystal Hester, having food issues in a alcohol treatment facility.
Oh, great. Where are you at?
I'm at Foundations Group Recovery Center in Columbus, Ohio.
Beautiful. How many days clean you got?
About 40.
Good for you.
I'm actually in with my therapist. She said
That's
she's
the
gonna
best
look at-
reason in the world to be Zoom.
Yes.
All right, go ahead, Council.
Have a couple of pieces because there has been a change in the attorney.
Okay.
My client is out of state, right, for the examination, but anticipating that I might need to file something asking, for example.
Can we give you that November date and give you enough time to file if you're going to? Good, thank you. All right, Ms. Hester, exam
Yes,
is
sir.
going to be the 26th. Unless council files some kind of motion, she'll keep you informed on that.
November 26th,
Yep. 12:30.
12:30.
I'll continue your bond and I'll wish you luck. Keep up the good
Thank you
work.
so much, Your Honor.
You're welcome so much. You're welcome.
Mr. Mays, did you need to speak to the prosecutor or you? or your
Yes, I
client?
do, please.
It's Mr. Mohammed?
Mr.
it's
Zelnick, are you ready
it's
on
domestic.
Trevette?
Okay, thank you.
Am I done?
You can stay there if you want.
It's like the old days.
Ms. Hester, you're all set.
Okay, thank you. Have a good day.
I see the face and I do that on the screen. Just go tell you.
Good morning. That's a nice tie.
Oh, I thought I had a bet. I thought you see.
Pretty tie. Yeah, very nice. Good morning. All right, we're gonna set an exam for Ms. Trevette.
Because I'm asking for an exam. I know it's jockeying to the.
I know, yeah.
And I certainly hope we don't get to entertain you. I'll let you pick the date where it's here. 26th work, sounds like you've got a load, but that might be a good day to set.
Yeah, we'll set one of the two. Heather, you want to set Mr. Zelnick's exam at 1 o'clock on the 26th?
Yes, please.
How's that?
Should be next day after Thanksgiving, guys.
It should be right in there.
You'll have something to celebrate. I think one of his family, Jermaine.
Oh, good for you.
It first.
All right, well, you know I'm gonna make it move fast. November 26th work for you. All right, your bond is continued. If you have a seat, we'll get you a printed notice.
Judge, we change. Thank you.
Good luck. You're welcome.
Take a seat right there, Judge.
Heather, anything online?
No. Nope, not yet.
Morning, Mr. Kaplan. How are you today? You can bring it here. And it still works.
Works. Judge, I'm not a technical guy.
Oh, I'm not either.
Yeah. Well.
What are we doing with Tackett, Mr. Kaplan? Is that you? Okay. All right. Hey, Heather, do you know where all that background noise is coming from? Oh, there it is. Found it. Hey, Tim. Mr. Robinson was in here and then he left again. So just tell him I'm ready.
All right, well, they sort that out. Let's go back to Judge Stevens.
You're charged with a third-degree felony of tampering or fabricating physical evidence with intent to impair it. It's like there was an investigation into a homicide, and it is alleged that you intentionally or knowingly concealed evidence, namely a firearm, to prevent its availability to be found as evidence in the investigation. If found true beyond a reasonable doubt, you're looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? Just over that.
She's a great Harris bad, yeah.
There's no around.
Do you find out this down, so it's just racist, but all there, yeah.
his persons and all that stuff. Sure. Did you see this one? But I will see it.
So they got some videos here. Huh? You've gotten all this discovery.
Charged with forgery.
It says,
I'll be right back.
Eddie Davis was involved in this investigation. His girlfriend deleted surveillance video. Was she charged with?
Yes, Your Honor, she was as well, tampering.
Tampering. They were able to retrieve the video and they a .223 rifle was used in the killing of this person. What's happened to this to Murchison?
Which their brothers, one's Isaiah, the other's Jason. He's set for trial on murder as well as essentially solicited another individual to commit murder of one of our witnesses in the case.
It says on January 9th, the defendant retrieved the rifle from Young's residence with the intent to conceal it from the investigation. And that's what they have here. When's this other trial say on the murder?
Yeah.
Hold on. Jason Murchison.
February the 2nd, Your Honor.
Okay.
Next year.
correct.
Who's the lawyer on that?
Buddy Reynolds, Your Honor. He was also on this case. That's part of why it's he was on both of their cases, had a conflict, and then had to Mr. West was appointed.
So today.
Good for trial, but also, Your Honor, Mr. Murchison has an ankle monitor on right now. He's never been in trouble before. He's never missed court. There's no victim in this case. This is not a victim case. It's the type of offense he's charged with in the case. I would request to take the ankle off now and add an extra expense.
No. Sorry. No, so we're talking about a homicide. That's serious, is it?
Well, absolutely. If he was charged with that, or
it's surrounding the homicide.
And Your Honor, we have,
and if he's charged with tampering or fabricating physical evidence, the investigation into the homicide. I mean, that's anybody that can tamper with evidence that could scuttle a case. How serious is that? It's serious. That's why he's looking at up to 10 years in prison. The legislature made it serious. So no, I want to know where he is. Get a resetting and it'll be set for trial. Sit over there before you go.
Get a resetting first. Right. Maybe get the rest of it.
Yeah. Okay, you ready, John, on yours? He left.
Judge, MIS is working on happens. I think you took a minute.
Okay, again, as a reminder, queued up somewhere on the top of the hour, we'll have the continuation of the Judge Wolf hearing that we weren't able to see the conclusion of yesterday. In the meantime, let's go back to Wisconsin, Judge Mogan.
On the record, in the matters 23 CF 172, 24 CF 208, 24 CF 208, I guess for two. We're here with State of Wisconsin versus Joseph Berg. We have the state appearing through District Attorney Kevin Schmidt in person. Mr. Berg appears in person with counsel Daniel Chapman. We're set today in these matters for a plea hearing and an arraignment. Before we proceed, are we in victims' rights compliance?
Yes, sure.
With regards to the arraignment, Mr. Chapman, were you able to go over the criminal information with Mr. Berg?
I did not specifically discuss it with him today, but he is well aware of the charges from previous discussions, and we were prepared to go forward with the plea today.
All right, so at least at this time, not guilties on
Yes.
those. Not guilty pleas will be entered on his behalf as it relates to those. We're here for a plea hearing now, a global agreement. Can you please recite the agreement for the record?
Your Honor, Mr. Berg will be pleading guilty to felon in possession of a firearm in 23 CF 172 and to felony bail jumping in 24 CF 208, specifically count 1 for failing to maintain absolute sobriety. There will be a joint request for a PSI, and at sentencing, the state has agreed to cap its recommendation at the DOC's recommendation. The defense is free to argue.
All right, okay, and Mr. Berg, that is the agreement that you've reached?
Yes, Your Honor.
Okay, with 23 CF 172, you did say we are in victims' rights compliance?
Yes.
Okay, I just wanted to make sure. And basis for the agreement and why it's in the public interest, Mr. Schmidt?
I think it's appropriate given the facts of the case. It includes a high felony with the felon in possession of firearm. It's a decision I made after after reviewing the body cam and specifically how the drugs were affecting Mr. Berg on the body cam. It kind of showed him in a rigid, non-responsive standing state for a long time until it started, whatever he was on wore off, and then he got confused and didn't know where he was.
Okay, all right. Thank you. So, Mr. Berg, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he essentially go over it with you word for word?
Yes.
And you understood everything on that document?
Yes, Your Honor.
Is that your signature on the second page?
Yes.
You were pleading guilty to 1 count of felon in possession of a firearm in 23 CF 172 and 1 count of felony bail jump in 24 CF 208. You are 38 years old. You have 10 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications other than a prescription medication within the last 24 hours?
That's correct.
And have you taken that prescription medication as prescribed?
Yes, Your Honor.
And is that a prescription that interferes with your ability to comprehend or understand anything that's going on?
No, Your Honor.
So you are in a state right now where you completely understand and comprehend everything?
Yes.
Now, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're being charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of that plea questionnaire. Did your attorney go over those rights with you?
Yes.
Did he go over them thoroughly with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights.
Yes.
You also understand that if you're not a citizen of the United States, your plea could result in your deportation.
Yes.
Do you understand with 23 CF 172, possession of a firearm by a felon, the state would have to prove on or around September 16th, 2023, you possessed a firearm in Burnett County, Wisconsin, having been convicted of a felony in St. Croix County, in Wisconsin, cases number 17 CF 262, 15 CF 199, and 04 CF 335, and in Washburn County case number 09 CF 92. So do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years or both?
Yes, Your Honor.
You also understand that with regards to the 24 CF 208, the state would have to prove on or around September 7th, 2024 in Polk County, Wisconsin, having been charged with a felony in Burnett County case number 23 CF 172, and having been released from custody, you intentionally failed to comply with the terms of your bond by maintaining absolute sobriety. Is that the one he's pleading to?
Yes, Your Honor.
All right. And so do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you do face a fine of up to $10,000 or up to 6 years of incarceration or both?
Yes.
Do you also understand that there's a recommendation to the court here, a joint recommendation for the court to order a pre-sentence investigation report in which the state is capped at whatever the Department of Corrections recommends for sentencing? Do you understand that I'm not bound to follow any recommendations?
Yes.
And do you understand what that pre-sentence investigation report is?
Yes.
And it's going to give me a whole lot of information, as well as the attorneys, about you, about your life, about your criminal history, about your upbringing, mental health, physical, all of those things, with that recommendation for sentencing from the Department of Corrections. So you understand I'm not bound to follow the Department of Corrections recommendation.
Yes.
And I'm not bound to follow the state's recommendation.
Yes.
Or the defense's.
Yes.
And so do you understand that I, in my discretion, can sentence you to the maximum possible penalties for each of those charges if I find it is warranted?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes, Your Honor.
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Did you go over both of those criminal complaints with your attorney?
Yes.
And in particular, there is that section in both of them called the probable cause section, where it basically says what happened those days and why you were charged with crimes.
Yes.
And for the most part, as it relates to the two charges you're pleading guilty to, are those facts accurate?
Yes.
Are you admitting that you did in fact possess a firearm and you are a felon?
Yes.
Are you admitting here today that you in fact did violate intentionally the conditions of your Burnett County bond?
Yes.
Are you pleading guilty to those charges because you are guilty of those charges?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at these matters thoroughly?
I assume so. It seems that way.
Has he discussed with you the facts of this case
Yes.
and what the state would need to prove?
Yes.
And did he discuss with you any potential for any defenses or possibly a lack of defenses in the cases?
Yes, Your Honor.
And so he negotiated on your behalf and he came up, he got this agreement with the state?
Yes.
And are you satisfied with his services?
Yes.
Do you have any questions for the court or your attorney before I proceed?
No, Your Honor.
Then as to 23 CF 172, possession of a firearm by a felon, how do you wish to plead?
Guilty.
As to 24 CF 208, count 1, felony bail jump, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The other counts and charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. And just briefly, quickly, Mr. Chapman, because there was a time where Mr. Berg may or may not have been there during the incident of this matter. Do you believe he's competent right now to enter these pleas?
Oh, yes. During the incident, it was drug and alcohol related, in my opinion.
And he's doing great since then.
I have never had any question about Mr. Berg's competence.
All right. And you believe he's entering his pleas freely, intelligently, and voluntarily?
Yes, he is.
Full understanding of the facts and what the state needs to prove?
Yes.
And any potential defenses or a lack of?
Yes.
All right. Okay, then the judgment of conviction is entered and the court is going to order pre-sentence investigation report. Long form. Agent does not need to appear, but should be available by telephone if questions are needed to be answered. As to bond, I'm going to guess you're not asking to revoke bond at this time, Mr. Schmidt?
I am not.
Bond will remain active. You are under all of those conditions of bond. If you violate bond, I'm letting you know right now that gives the state the ability to do what they want with regards to arguing. Right now, they're capped at the PSI, so follow your bond to the letter, okay? And when the DOC, Department of Corrections, contacts you for your input in this, you are ordered. You have to comply with them. It's only in your best benefit if you do. I just need to make sure that I have your address is still on Valley Drive.
Yes.
And telephone ends in 3623.
No, Your Honor.
May I get an updated?
It is 612-528-8330.
May we send you text message notifications if we need to?
Yes.
Okay, so I'm not revoking bond at this time. I'm ordering you to comply with DOC. You must report immediately after here to go to DOC just to make sure that they have your info and all of those things, but they should. They may or may not want to get started today. I'm not sure, but since you're coming from such a distance, that's why I'm saying you should just go report today, see if they want to have any contact.
Where is that?
It's the kitty corner from the courthouse.
Okay.
You should be able to see it when you go towards Webster. It's on your right.
Okay.
Okay.
Just pull out of the parking lot, turn left, and it's right up
We
there,
need a
right?
date for sentencing. And Mr. Chapman, it's going to go into the new year. Is that okay?
Oh, yes.
I can do January 6th. Wait, did I sentence you? No. I can do January 6th, either at 9 or at 11 or anytime in the afternoon, or January 7th. Oh, wrong week. Sorry. I need to look at a Schmidt week. I can do January 20th, or I must have had something come off because the week of the January 20th, 21st, 22nd, and 23rd, I'm wide open.
That's still Jose's week.
Oh, darn it.
He did the week of the 12th.
I know, but I have, we're booked solid. Well, I guess January 26th, can you do 1 o'clock?
No, Judge, I need to be in Polk County at 1 o'clock. I am back in front of you at 2:30.
I guess I can take off my prelims. I can do it at 3. Do 3 to 4. All right.
Just so you know, Judge, Mr. Berg is on probation and doing well right now from his Polk County matter. So
I thought he had his sentencing.
if you're trying to think I have to get this done as soon as possible and you're trying to squeeze in prelims, I think we're fine waiting, but
My thought was not trying to get it done as soon as possible, but victims
understood.
trying to get it done as soon for any victim involved. So. that's
Okay.
all.
The January 26th at 3 o'clock is just fine.
Okay, we'll see you then, January 26th, 3 o'clock. Follow your bond to the letter, okay? All right.
Best thing you can do.
Anything further, Mr. Schmidt?
No,
Mr. Chapman?
No, Your Honor.
All right, then we are adjourned.
I don't know if it's been part of the court's thinking or if it's been, Commissioner Krupa's other things, but our office is able to be double booked again on Thursdays for prelims if you
If we
want to
need
start
to,
doing that
whoever
again.
knows what to do, and that's good.
Okay, so Barbara just put in the chat, Dan, I wonder what the tally would be of all the people that can't vote due to their crime. Well, I have the answer to that. The Sentencing Project's Locked Out 2024 report. It estimates that about 4 million Americans, about 1.7% of the voting age population, is currently barred from voting because of their felony convictions. That number's trending down. It was 5.9 million in 2016, so there have been efforts to give people back their voting franchise over the years. Interesting policies vary. Maine, Vermont, and D.C. actually allow people to vote while they're in prison. But then you have like Florida and Tennessee that are the two most restrictive states, and they actually have the highest rates of removing the franchise of voting from felons. So that answers your question, Barbara. Let's go back to Judge Stevens.
We now call cause number 24 CR 2224, the state of Texas versus, is it Caraca or Caraca? Caraca LaFleur. You're here with Mr. West, your attorney and a state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, Your Honor, please.
In summary, this indictment alleges that on or about January 14th, 2024, in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle while intoxicated with a child passenger who was under the age of 15. This is a state jail felony, which carries with it, if convicted, no less than 180 days in the state jail, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable?
Yes.
An agreement's been reached where you would be pleading guilty, found guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, fined $500. And there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
Yep, the pad is acting.
Yeah, that's. Almost, it's not quite. Always in its post, so.
How do you plead to this? Guilty or not guilty?
You're guilty or not guilty?
I'm guilty. Yes.
Are you pleading guilty voluntarily and because you are guilty of what this indictment alleges?
Yes, Your Honor.
Can I show you what's marked as State's Exhibit 1? Did you sign that document? Understand it, discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime. And any lesser included offenses, you giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. The State's Exhibit 1, made a part of the record for all purposes without objection. Pre-sentence report is away.
Yes, please.
I am going to follow this agreement, and I'm going to find, Ms. LaFleur, that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this state jail felony. I will follow this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended and you are placed on regular probation for 5 years. You must pay a fine of $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. What do we have for intoxication?
The very last page.
You will have, you must have an auto ignition interlock system as a condition of probation in any vehicle you operate. What about alcohol usage? What do we know?
It's already restricted.
Yeah.
It's all, that's restricted on all the probations and shitties.
I'm talking about proactive work for.
Well, we can have some mental substance abuse assessment. That's what the state.
Okay.
Yes, there's. And follows the regulatory.
They will evaluate you on the issue that caused this. It's like alcohol.
That's correct, Your Honor.
What was the blood alcohol level?
0.160.
160. It's twice the legal limit. How old is the child? How old was the child?
He's just,
Ma'am?
Should 3.
Yeah.
They're just along for the ride.
Yes.
I mean, you got to take care of them. It's irresponsible for you to be operating a motor vehicle, but you have a child. Hopefully the child was properly in a seat that but nonetheless. 4,000-pound missile can do a lot of damage to people when they collide with things, which is all a vehicle is. It has to be operated responsibly, not only for the driver, but for the helpless passengers who are along for the ride. How many children do you have?
On that big boss,
I'm sorry?
that big Casey.
3.
Big boys.
I'm a parent too. There. Something happens, it's our fault if we're not acting responsibly because they have to rely on us, the parent, to take care of them. You do love your children. You got to act like you do too by making sure that they're safe. All right, do you understand what has happened here? There's we don't have a minimum time in jail on this.
Not for this time.
Not for this.
Not for a DWI 30, not for a.
Yes, that's correct.
Anything else to add?
Nothing from the
Okay.
state.
You're in recess. Let's see the probation officer. Thank you. John, you got.
Okay, folks, we're going to switch from TCF Live to TCF Memorex. As I promised you, we would continue with the Judge Wolf hearing that we didn't see a conclusion to yesterday. So this is from yesterday after they came back from recess. They were in the middle of testimony from an officer that was involved in the situation. The long and the short of it, if you weren't with us yesterday, this was a hearing regarding an adjustment in a bond amount. So that is where we're at. I have not watched this, so I have no idea how this concludes. We're going to find out together.
Sure.
George? Oh, missed it. George has caught the ball. Hooray! Well done, George. Now you throw the ball to Pepper. Oh, try again. Throw it out for me. Pass was long. Yeah. George cannot throw the ball past somebody big. Come on, George. Give it to me.
My kids are here by themselves. I understand that. I'm not. Turn around, hands on your back. Yes, sir. Did you not hear us knocking on the door? I heard somebody knocking, but I thought it was mine. You didn't hear me yelling police department? No, sir, I did not. You know why we're here? I have no idea. Okay. We'll get to that. Hey, you let them know that they can come in here with this for these kids now. Mom. Hey, Mom. Is that your mom? Who is she? They don't know her. She's at, she's at her house. No. So you taking my kids? I'm not.
So I know that you're not the one who took that video, but would you say that that fairly and accurately depicts you arresting Mr. Beard on the date that you were testifying to? Okay, so that's an objection. I would just introduce a USB stick with that.
I won't be considering it because I haven't watched it. But
Well, I was going to publish it next.
there you go.
How would you like me to publish it? I guess.
Well, it doesn't matter to me how you wish to publish it, but if you're showing him a video, and if I'm going to have to consider it, I'll have to watch the same video. It would have been probably easier to put it up there, but it doesn't matter. Are you wanting me to watch it? Is that correct?
Yes, Judge. If you just want to use my laptop, I think that might be the easiest. Unless there's like a HDMI I can plug into. Should be more prepared for that, but it's kind of. Here you go, Judge.
George? Missed it. George has caught the ball. Well done, George. Now you throw the ball to Pepper. No. No, try again. Throw it out.
George cannot show the ball past Money Pig.
Come on, George, give the ball to me.
My kids are in by cell phone. I'm not. Turn around, hands on your back. Yes, sir. Did you not hear us knocking on the door? I personally knocked, but I thought it was my. You didn't hear me yell at the police department? No, sir, I did not. You know why we're here? I have no idea. Okay. We'll get to that. Hey, you let them know that they can come and do this for these kids now. That's my mom. Their mom. You say the mom? Who is she? They don't know her. She's her dad. No. So you take my kid? I'm not.
With that, Judge, that's all that I have of this witness.
You right?
Yes, Judge. Officer Field, you saw the video that you were just showing, correct?
Yes, ma'am.
And you've been testifying from your memory up to now, correct?
Yes, ma'am.
You were never able to review your body cam footage
No, ma'am.
due to it being lost?
Yes, ma'am.
Okay, and in that video, you can see one of the children in a playpen, correct?
Correct.
Having watched that, does that refresh your memory as to what,
It does.
can you tell the court specifically what you saw that day?
I would just say that it's walking down the hallway. Obviously, a very stressful situation. I distinctly remember seeing a child on each side of Mr. Beard. I distinctly remember Mr. Beard when I told him to come to me. I said the word usher. I'm not sure what the best way is to describe it. The child that was next to him, I'm not sure if the child was on his lap or on the bed. I don't dispute the video, but
You do recall seeing a child being, well,
yes, ma'am.
between you and him?
Yes, ma'am.
At least one child?
Yes, ma'am.
Okay. And again, just for purposes of refreshing the court's memory, the door was barricaded?
Yes, ma'am, it was. And photos were taken of the crib that barricaded the door.
Okay. And is your testimony true and accurate to the best of your knowledge?
Yes, ma'am, it is.
And this happened back in January of this year, true?
Yes, ma'am.
No further questions.
Recross.
You testified that you took a photograph of the baby gate that was in front of the front door, that was behind the front door?
Yes, sir.
That's all.
Nothing further. Judge.
Thank you. I'll sure you may step down. State you may call your next witness.
You're on state, we'll call Caitlin Miller.
Caitlin Miller.
While we're waiting for that next witness, Rahul, thank you for the $10 that you donated via courtroomfiles.com. Very much appreciated that. Thank you so much.
I ask you to raise your right hand and face the clerk.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Thank you. Now take care.
Ms. Miller, can you state your full name for me, please?
Caitlin Burnett Miller.
Scoot up to that microphone. Everybody has a hard time, but you have to basically directly speak into it for the pickup. Okay.
Ms. Miller, were you in a relationship with Mr. Ethan Beard?
Yes.
Okay. And did that end back in January of 2025?
Yes.
Okay. And
Speak up now.
Yeah, you're gonna have to really
This
get
lady
close.
here on this side of me has got to write down everything that you say. So when you talk softly, she can't hear you. So be sure to speak up.
just as loud as you can. You live in Humphreys County or in the city limits of Waverly with Mr. Beard, correct?
Yes.
Okay. And what was your address at that time?
106 Powell Avenue
in Waverly.
Waverly.
Okay. And did you speak with Officer Field of the Waverly Police Department back in January 2025?
Yes.
Okay. And what did you tell him?
He came to my mother's home, which is where I was at the time, and told him what my 8-year-old son had told my ex-husband and the abuse that had been going on with us and the children.
Okay. Did you specifically tell him about several instances where you were assaulted by Mr. Beard?
Yes.
Okay. Can you tell the court about, whether or not it was physical abuse or what kind of abuse it was?
Physical and mental.
Okay. And how did he physically abuse you on the occasions that you told Officer Field about?
He tied a hoodie string around my throat and tried to strangle me. I had a bruise on my arm from where he punched me. I had an imprint of a water bottle on my side where he threw it at me.
What kind of water bottle?
Dasani.
Would that be a metal or plastic?
Plastic. He pushed me over on our 3-year-old daughter, trying to get a hold of my neck.
Did he grab you by the throat multiple times?
Yes.
And when he grabbed you by the throat, how did he grab you?
With both hands trying to strangle me.
Did it leave marks on your neck?
Yes.
Did you take photos of those?
Yes.
Did you provide those to law enforcement?
Yes.
Did he also threaten to kill you or harm you? What specific threat did he make?
That he would put me 6 foot under the ground and make sure that I didn't breathe again.
Did he also threaten to slit your throat?
Yes.
What did he say when he was saying that?
That he was going to, I don't want to cuss.
It's all right. Go ahead.
That he would slit my throat if I took his children away from him.
Okay. Did he ever hit you with his fist?
Yes.
More than once?
Yes.
And can you tell the judge the approximate time frame that these incidents occurred?
No, October, November, December of 2024.
And you have photos of multiple injuries, correct?
Yes.
And you documented those and provided those to law enforcement?
Yes.
Stating.
Staying, don't lead the witness.
You took photos of the injuries?
Objection.
Oh, let me rephrase it, Judge. Did you take photos of the injuries?
Yes.
Did you provide those to law enforcement?
Yes.
How did you provide those to law enforcement?
I believed they were time-stamped photos that were either airdropped or sent to him to his email.
Did you have any other photos that you provided to law enforcement?
I provided everything that I had that night.
Were you aware that Mr. Beard had broken the lock on the water meter, whatever it is that you're at the residence?
Was not.
You were not aware? You're aware that the water that you had was not being paid for?
No.
In fact, did you give Mr. Beard any money Yes. What'd you give him money for?
The water bill and multiple other things. I mean, he didn't work
How long a period did he not work for?
the entire time we were together, 5 years.
And you worked?
Yes,
Were you working pretty much the whole time?
yes.
So he was home alone with the children the majority of the time? Are you afraid of Mr. Beard?
Yes.
Did Mr. Beard try to contact you once he was in jail?
Yes.
Did he speak with you on the phone?
I never spoke to him on the phone.
But did you answer a phone call from him?
Yes.
Okay, and he spoke
And
to
he
you?
spoke, yes.
And did he try to call you multiple other times?
13 times.
And this was after he had been arrested and in jail, correct?
Yes.
No further questions, Judge.
Simpson, you may cross-examine.
Do you recall roughly when the last phone call was?
The last phone call that he, from
Yes,
jail,
that you were seeking?
I believe it was January 17th. It was the night my dad died. So the 17th.
And, okay, so I kind of want to ask, there's some questions about the photographs you sent to Officer Field. You testified that you may have airdropped it to him, is that right?
Yes.
Okay, so you took those photographs with an iPhone, an Apple iPhone?
Yes.
Talking about the water issue, you testified that you didn't know anything about the water issue. Is it fair to say that you had informed Officer Field on January 12th that Mr. Beard was the one giving you money for the water bill?
I gave him money for the water
Or
bill.
sorry, that you gave Mr. Beard money for the water bill?
Yes,
And that was reported to Officer Field at the same time, like when you first spoke to him?
I believe so.
When did you go to change the water into your name?
I don't remember the exact date. 2 weeks, a week or 2 weeks. I don't remember the date.
After Mr. Beard was arrested?
Correct.
Now, Mr. Beard is charged with two counts of this assault, right? One on December 1st, one on December 2nd. Do you recall what happened on December 1st of 2024?
I don't remember the exact dates.
I'm asking you specifically about the time in which Mr. Beard was alleged to have threatened you
Okay.
on December 1st. Do you recall that?
I don't remember specific dates to each threat now.
The one where he said that he would slit your throat if you took the children away?
Okay, yes.
Do you recall what was the context in which that was said? Like what was going on? What happened before that?
Usually me complaining about him getting a job and helping with bills would start the argument.
Do you recall specifically if that's what that was that day?
I don't recall specifically, no.
Do you recall whether you took notes about it, or how did you recall that it had happened when you spoke to
I
Officer
have
Field?
photos that are time stamped and I do have notes in my phone, but sitting here right now, I don't remember specific dates.
When he threatened you to slit your throat, I mean, did he have a knife?
No,
Do you recall making a written statement that gave sort of a timeline of all of the abuse to Officer Field?
yes,
And to the best of your knowledge, did that written statement contain everything that you recalled at the time?
yes,
So if that written statement on December the 1st just said the only thing that it included was the threat that he would slit your throat, but there wasn't any sort of physical abuse, would that be accurate?
no, there was physical abuse.
I mean, on that day.
I don't remember specific dates.
I'd like to show you a document just to refresh me.
Okay.
Was there any, to your recollection, did you allege that he physically assaulted you on December 1st, or was it just the threat?
Don't put his hands around my throat.
On December 1st?
Yes.
Is that reflected on that
multiple
written statement?
occasions. He grabbed me in the living room and pushed me on top of our 3-year-old daughter.
Okay, if I know it true. If I could show that to you again, does that say December 1st or December 2nd?
December 2nd.
So would it be fair to say that that was December 2nd?
Correct.
So what you put in that written statement about December 1st, was that accurate?
Yes.
And good. Was there anything on December 1st about him putting his hands on you?
Specifically on December 1st, correct? No.
But other than what's in that written statement about that specific date, your testimony is today that you don't have a clear recollection of what happened?
I do have a clear recollection. I just don't know specific dates.
So that's what I'm asking. You can't really differentiate what happened on this date versus that date.
Sure. Okay.
That's all, Judge.
Anything further from the state? Thank you, ma'am. You may step down. State may call your next witness.
State has no other witnesses, Judge.
State has rested their proof. Do you have any rebuttal proof, Mr. Sensing?
No, Judge.
All right, I'll hear you an argument.
I did a little reading during lunch. I think that at the outset, it's important to remember that what we have here before the court today are a set of allegations. A set of allegations that are unproven and that have not been subjected to a jury trial, in which Mr. Beard stands presumably innocent. And so this court's job, as I'm sure it well knows, is to determine what is the least onerous conditions that are necessary to make sure that Mr. Beard appears in court and to make sure that Mr. Beard isn't going to be a danger to the community upon release. And there are a number of factors that I think I'll get into, but which point towards either giving him a signature bond with a GPS monitor or giving him a bond of no more than $5,000 or $10,000 bail amount. So starting with the fact that it's undisputed that Mr. Beard has been a resident of this county for his entire life. He has no meaningful contacts outside of this county. He is not a flight risk. So in terms of making sure that he's going to appear in court and run away, I mean, there's no evidence that would support that at all. As he has no criminal history except a B misdemeanor driving on a suspended license. He has no record of any failure to appears. And certainly he doesn't have a criminal history that would suggest that he's at all a danger to the community at large. Even if he is convicted. Well, let's talk about the strength of the state's case, starting in 15061, water theft. If the court looks at the bill that I tendered as an exhibit, you'll note that the only water that was actually stolen, this is a theft of property case, it's like $500 or $600 worth of water. Now, maybe the state has a case about a misdemeanor theft, but in terms of this felony theft, where they're including late fees and broken walk fees, service fees and all of that, that's not what was stolen. Okay, So this is not a felony theft case. It is a misdemeanor theft case. And it is a misdemeanor theft case in which the vandalism charge was filed outside the statute of limitations. If Mr. Beard had been stealing water allegedly since January of 2023, the lock would have been cut then. This was not filed within the year. So the state's strength on the vandalism count is non-existent. Turning to 15064, in its amended response to my motion for a bill of particulars, the state has amended its indictment or superseded its indictment to charge Mr. Beard with child endangerment. It claims it's a B felony, but if the court looks at the statute, that is child endangerment by exposure to a non-Schedule 6 controlled substance. And there's absolutely no evidence at all to suggest that Mr. Beard is guilty of that. And even if Mr. Beard was guilty of the A misdemeanor child endangerment, which would have been the proper charge, there's no evidence that he placed his children in imminent risk of harm. There was never a gun pointed at them. There was never a taser pointed at them. There's no evidence on that video that he ushered them in front of him to try and blockade them between him and the police. And he's not charged with any of this 404B evidence about the house or the bruises or this and that. He's only charged with child endangerment. And if the court looks at the state's amended response to the bill of particulars, the allegation is that he put his children at risk if he failed to answer the door. Sweet case. Possession of unlawful drug paraphernalia, well, there was no marijuana found, and there's been no testing to show that it had marijuana residue on it, so I would argue that that's also weak. 15065, the gay misdemeanor domestic assault, aggravated assault, violation of no contact order. You know, that sort of stuff that's going to have to go in front of the jury. Obviously, the allegation has been made over a month after the fact in the context of a different investigation entirely. But whether or not if that's sufficient proof beyond a reasonable doubt, she says there's photos of these injuries. They are not in evidence before this court. All we have is her allegation that it occurred, and she testified that she had no clear memory about what happened. And then again, there's all this 404B propensity evidence that was put on that is not relevant to the crime for which he's charged. His bond is currently set at $75,000. And at the end of the day, I think the state's going to get, at best, some misdemeanor convictions and maybe a C felony aggravated assault. And if the court looks at TCA 4035-1026A, he is a presumptive candidate for probation. He has no criminal history. There have been no efforts to rehabilitate him that have failed. He will be guilty of a C felony, which makes him a presumptive probation candidate. So he's likely to get a probated sentence where he to be found guilty after trial. I don't mean to presume, but that's what the statute says. So in terms of the proof, strength of the state's proof, and the likely sentence that he would receive if convicted, I would say that those don't bear upon him being a flight risk either. People get probation for these sorts of things all the time. And again, I'm not trying to put words in the court's mouth, but we'll see what the proof comes out of trial and the sentencing. He has multiple members of the community who have vouched for him, multiple members of the community who gave testimony that are at stark contradiction to what the state's trying to paint here as far as Mr. Beard being this abusive person. And so when considered in the context of, is he going to appear in court? Is he going to go out there and terrorize the community if he's released? And he's presumed innocent. All of these factors favor releasing him on either a signature bond with a GPS monitor, no contact order with Ms. Miller and the children. And I should say, the violation of the bond conditions, I think the officer, we didn't have the recording, but Officer Field himself testified that he got through to her once and he wanted to apologize. That's what he wanted to do. That's why he called her. He didn't call her to threaten her. He didn't call her to try and tamper with her testimony or anything like that. So if the state gets up here and says that he's a danger to her because he violated his bond restrictions, I think it should be said that the reason that he didn't care if he got into trouble, maybe he will, is because he felt like it was important to apologize. Is it wrong? It's illegal. But does that show that he's a danger to her. I don't think it does. And so what I would ask the court to do, in consideration of Mr. Beard's fundamental right to be released on its minimum amount of bail conditions as is reasonably necessary to make sure he shows up to court and doesn't reoffend. I would ask the court to, like I said, to give him a signature bond with conditions that we have a GPS monitor so that we can keep tabs on where he is. He's not going around here with the kids. Or set bond at no more than $5,000. Thank you. I think I put $10,000 in my motions.
General McLeod,
Yes, Judge. Judge, first of all, state would disagree with defense counsel's summation of the strength of the state's cases here.
shocking.
Starting with the vandalism and theft case. Your Honor, it's the state's understanding that the statute of limitations activates, for lack of a better word, once the victim becomes aware of the crime. The city of Waverly was not aware that the lock had been broken. Now, whether they should have been aware or not is another question, but they weren't. When they did become aware, they notified law enforcement immediately, and he was charged. The state also disagrees with defense counsel's assessment that it's only a misdemeanor theft as opposed to a felony theft. But again, the state does feel that is a matter to be addressed at trial and a jury question. As far as the aggravated assault, the state believes it does have a strong case. Your Honor, the state didn't introduce all the photos because again, this is a bond hearing, not a trial. But there's the victim testified, the officer testified separately, the victim was outside when the officer testified. Their testimony corroborated one another. Photos have been provided, defense has those photos. The state believes that the assault case is very strong, that there will be a conviction, and further, the state would argue that aggravated assault is in the category of crimes that is not listed as probatable if convicted in a jury trial. I understand the court would still do that, but it's not necessarily clear that that is a charge once convicted that one could be put on probation for. Moving to the child abuse statute, Your Honor, defense argues that 39-15-401-D1, which reads in full, any person, let me find it. Make sure I reference the right one. Any person who negligently by act or omission engages in conduct that places a child in imminent danger of death, bodily injury, or physical or mental impairment commits a Class A misdemeanor, except that if the abused child is 8 years of age or less, the penalty is a Class B felony. Subsection 2 then goes on to say, for purposes of this subsection, a person engages in conduct that places a child in that situation if the child is exposed to a drug that's not Schedule 6. The state's reading of that statute is that that is simply one aspect of what the statute is intended to cover. It's not necessarily reserved exclusively for children exposed to drugs, but for any conduct that can put a child in that danger. That's why Mr. Beard was indicted under that statute, due to the state's belief that his actions would fall into that category. The state disagrees that that law would apply only to drug offenses. The violation of bond conditions. Mr. Simpson seems to think that, or his argument at least, is that the defendant's violating of his bond conditions can be excused if the purpose of the defendant's phone calls are to apologize to the victim. The state would argue that perhaps Mr. Beard was trying to influence or coerce the victim to drop her allegations, maybe accept his professions of being sorry and let him off the hook. So the state doesn't believe that his apologies are sincere. In fact, the state would argue that his conduct in repeatedly violating those bond conditions, while stating that he was aware that he knew he was doing so and would get in trouble, shows a complete disregard for the law and for orders of the court. And again, Your Honor, this is a bond hearing, it's not a trial, as you're aware. Mr. Simpson states in his motion that the state has submitted no evidence or articulable allegation that would, if true, make the defendant guilty of child abuse and neglect. And the state just simply disagrees with that. We believe that the evidence is overwhelming in this case, Your Honor. Yes, the pipe wasn't checked for marijuana residue, but the jury can determine whether or not they think it was being used for that, or he was just smoking tobacco out of it. Your Honor, the state does agree that under the bond statute, there are multiple requirements and factors that the judge would look at. And several of those do favor defendant as far as length of residence in community, members of the community to vouch for him, the fact that he has a very minimal prior criminal record, that he wasn't already on release when he committed a majority of these offenses or is presumed charged with them, except for the violation of bond conditions. But Your Honor, the state does feel that based on the testimony we've heard today, that the probability that he would be convicted of the majority of these offenses is a great probability, that he is a danger to the community. Based on the testimony, Your Honor also heard that there are other children in which he has not been charged that also have bruises and marks of abuse on them. As far as employment, we heard that he hasn't had a job for 5 years. That would also favor the state. But in summation, the state would say that the bond of $75,000 is more than appropriate. But if Your Honor does, he'd be required to pay for a GPS monitoring device and also pay for the victim to have the notification as well. Thank you, Judge.
Findings 2 through 8.
First of all, got the jury instruction here. With respect to this B felony child endangerment, it's an act, it's an uncontroversial canon of statutory construction where the statute embraces a general, something general, and then something specific. Specific parts should be limited to that. This statute, 3915-401, already has a child endangerment. That's a general child endangerment. And that's in subsection C. It's class A. Then in subsections D and E, it has special drug exposure child endangerment. And the fact that it has one for meth and for fentanyl underscores the fact that those two subsections are limited to drug exposure by a methamphetamine or some other non-schedule 6 controlled substance, which includes marijuana, schedule 6, or again in subsection D2, fentanyl, which increases the penalty to an E felony rather than an A misdemeanor. So respectfully, I think that Tennessee Sentencing Commission, when they wrote the jury instructions, agree with my interpretation, and I can't see any appellate court not agreeing with my instructions. So it's an A misdemeanor child endangerment. Again, if it's child endangerment at all, there's no imminent threat that I heard today. And the next thing that I want to address is the state's talking an awful lot like he's already been convicted and we're at a sentencing hearing. We're not here to punish Mr. Beard for what he made a child. We're here to assess is he a danger. And again, these bond violations. There's nothing that the state's speculating, well, maybe he was trying, even though he didn't say anything that would suggest that he was trying to influence her testimony, maybe because he felt bad and apologized. He had this plan to try and get her to change her testimony, even though that wasn't expressed. So does that make him a danger to her while he stands presumed?
Can I respond to? I'm
You
sorry.
may, the public defender will have the final say no matter what, but I'll give you another opportunity if you want to respond.
Well, Judge, I was just wanting to say that the state's argument is based on Mr. Simpson's argument that we don't have, the likelihood of conviction is low. We know we're not at a sentencing hearing. But I did want to briefly point out that looking at the statute for child abuse and neglect, 3915-401A refers to a person who knowingly and other than by accidental means inflicts injury on a child. Subsection B refers to a person who knowingly abuses or neglects a child to adversely affect their welfare. And subsection D, which is the one that he's charged under, refers to negligent acts, including, it says by act or omission. So state would argue that different things are being met by each statute. And this is section D is referring to negligent behavior. It doesn't have to be intentional. That's all the state wanted to say.
Simpson, you have the final say.
Other than the fact that if the legislature were to criminalize negligence in such a way that you might potentially, possibly put a child in imminent danger would be horrifying. But also, it stands to reason that if negligence is the standard, then it's exposure to a controlled substance. And again, she overlooks, she goes through subsection A and subsection B, and skips to D. Because C is where you have child endangerment by a parent who has a parent or custodian who actually has the duty to care for a child, puts them in imminent danger of death or serious bodily injury. And I suppose I'll end with this from Professor Lawrence Tribe, and it's a quote that I think bears saying. It's from the Law Review article that I heard at our conference, and it's this. Quote, the system will appear to be it's about Bell arguments. The system will appear to be malfunctioning only when it releases persons who prove worse risks than anticipated. The pretrial misconduct of these persons will seem to validate and will indeed augment the fear and insecurity that the system is calculated to appease. But when the system contains persons who could safely have been released, its errors will be invisible. And so this court errs too harshly on Mr. Beard, if he could have been released with the least onerous terms possible to ensure that a man in a free country who stands presumed innocent until proven guilty doesn't stay incarcerated for over a year for crimes for which he has not been convicted. I would just ask the court to account for that too, because I know all too often all the weight's on danger of the community. When somebody gets cut loose and they do something bad, it makes us all look bad. But I think that we should pay attention to the other side too, because again, it's part of what makes this country great. Thank you.
Well, what makes this country great is the fact that we do have a system of laws and rules, and we have a constitution that guarantees people to have certain rights that are protected by law. One of those rights is the fact that a person is presumed to be innocent. So we have that argument to make that this public defender has certainly made many times here today, is the fact that Mr. Beard has not been yet convicted of anything. So the court has to consider the evidence that is presented at this hearing. And the evidence that has been presented at this hearing is consisting of multiple people who have testified about Mr. Beard and his conduct and his character and so forth, in the type of person he is and how he's nonviolent and so forth and so on. Contrary to that, and how he's reliable and all of those things are presented as a means of trying to satisfy some of the factors that are set forth in the Bell statute. And I'll touch on those in a minute. The state has presented evidence through the testimony of the officer and the victim of the alleged victim in one of the cases that tends to contravene or contradict the testimony of all of those character witnesses of Mr. Beard. So the court is cognizant of the fact that this is not a trial on the merits and beyond a reasonable doubt, and that is not the standard that the court applies in a bond reduction hearing. So we can argue all day long that a person is presumed to be innocent, and certainly under that, everyone would be released without any kind of restriction on their liberty because they're presumed to be innocent. But our law provides that there are certain factors that must be met, and that a recognizance bond or a bond of appearance can be required of anyone who is charged with a crime. And while Mr. Beard is not yet convicted of anything, one of those charges is a very serious charge of aggravated assault by strangulation. Now, the court is aware of the fact that while he has not been convicted, and Mr. Simpson argues that these are allegations that are unproven. There is truth to that, but for the purposes of this bond hearing, this court finds that the credible testimony of both the officer and the victim in the case established that there is a high probability that the defendant is in fact guilty of these offenses, based on the uncontradicted testimony of the victim alone, that he did in fact attempt to choke her and did in fact threaten her and so forth. Yes, that is not proof beyond a reasonable doubt, but that's not the standard for a bond hearing. The bond hearing is for me to determine what factors there are present and what factors would be required. The fact that he violated his bond conditions by contacting the victim, attempting to contact her by the evidence 13 times, and only connecting with her, answering it one time, and then, as Mr. Sensing points out, he may have done so to apologize. Anyone who's dealt with domestic violence cases on a regular basis, and I've done it for longer than I would care to remember, there is a pattern. And we often wonder, why do victims of domestic abuse, especially women, continue to stay in relationships where they're abused? One of the patterns that we see consistently is that that person says, well, he's promised to do better. There was a promise that I'm sorry, I apologize, I'll promise to do better. And so they stay with them because they have children or other factors. So the fact that Mr. Beard contacted the victim in violation of the bond condition, in this court's opinion, just to apologize is nothing more than consistent with what abusers often do in cases involving a victim. They try to apologize to try to lessen the punishment that might be inflicted upon them. So those are the findings that I make specifically, factually, in this particular case, applying my findings to the factors that are set forth in 4011-118 of the Tennessee Code, which have to do with the amount of the bond and the factors to be considered. The court looks at the defendant's length of residence in the community. He's a lifelong resident of the community, and that is a factor that favors him. 2, the defendant's employment status and history and financial condition, provided that his ability to pay shall not be considered. He is not employed, and therefore that's a factor that does not favor him. 3, his family's ties and relationships. He obviously has family ties and relationships with friends and people who have come to court to testify for him. That's a factor that does favor him, although clearly their opinion of his personality and so forth runs counter to what some of the other proof was in this case. That's not always unusual for someone to not, family members to not always see the other side of the family member's character. The dependent's reputation, character, mental condition. Again, the evidence of character here has been introduced, is the family members and friends of the defendant who vouch for his reliability and trustworthiness and so forth, and the fact that he's not a violent person. His prior criminal record, he has no prior criminal record. So that would be another factor that would favor him. Nature of the offense and apparent probability of conviction, likely sentence. Again, the argument is made that he's not yet been convicted, but the proof that's been presented at this hearing presents a strong case that indicates that if these photographs are introduced at trial, if in fact he has done these things, that there's a, and the evidence before me at this hearing is that there's a strong case that he has likely committed the assault against his girlfriend and Ms. Miller, and that the fact of the matter is that it's a strong likelihood that he may be convicted of that case. He is charged in that particular case with domestic assault and aggravated assault in violation of a protective order. No question he violated a protective order. Even Mr. Sensing admits that, but minimizes it by saying he was just doing it. He was violating that to apologize. And in the testimony before me was he knew he was doing something that he wasn't supposed to do, but he did it anyway. I think that there's, at least in many of those cases, a strong probability of conviction. As to the child abuse, neglect, or endangerment, I'm of the opinion that those cases may not be as strong because of the nature of the statute. That will be something that will have to be dealt with, but I do not place great significance on the strength of those cases. The theft of property and vandalism obviously is a circumstantial case. I have the opinion that based on the testimony that's been offered, that the circumstantial evidence is strong that Mr. Beard was the one who cut the block off, and that was the reason why the theft of water. We can minimize the fact that it may have been a smaller amount of water as what was said, but I think the statute would allow the consideration of the actual amount of water along with any other damage to the property. So I think that there are two of the three indictments. There's, in this court's opinion, a fairly strong probability of conviction. The sentence to be imposed on an aggravated assault case by strangulation depends on the judge, the sentencing judge, and all of the factors. But it's not an automatic just because he has no prior record that he would be entitled to probation. It would be considered, but it is not an automatic thing. As a result of that, the court who hears the case and has to do the sentencing would have to consider all of the sentencing considerations set forth in the Tennessee Code, one of which is the fact that a sentence should be imposed that does not diminish the severity of the offense. And that would be something that clearly the sentencing judge would have to consider. The identity of responsible members of the community will vouch for his reliability. Obviously, those people have appeared today and testified. Any other factors indicating the defendant's ties to the community are bearing on the risk of the defendant's willful failure to appear, including but not limited to whether he is lawfully present in the state. I am of the opinion that one factor that this court places great significance upon is the fact that he violated the bond conditions in the past by contacting Ms. Miller, and that indicated that he did so knowing that he could likely get into trouble and knowing that he was violating the law when he did so, but he did it intentionally. And again, there are ways you can explain it. One of those options is that he was genuinely contrite and wanted to apologize. Another possible explanation is that he, like many other abusers, was attempting to minimize the punishment to himself and to try to sway the victim in the case against testifying against him by apologizing and trying to say that I won't do it again. So applying all of those factors and considering the severity of this court and the amount of the current bond, the court finds that the bond should be set at $50,000. He will be required, if he makes that bond, to have a GPS monitoring device installed at his expense. He would also be required to pay the expense to make sure that Mrs. Miller would have the ability to monitor that, whatever the law provides regarding that. In addition to that, he is to have no contact with Tiffany Miller whatsoever, by directly, indirectly, by text message, by mail. He'll have no contact with her, period. And that is a court order that will apply whether he makes bond or not. In addition to that, he will only have contact with the minor children that were in his care at the time that he was arrested, pursuant to an order of the Domestic Relations Court or the Juvenile Court. That is, my opinion, an order that is required for the safety of Ms. Miller, as well as, and I'd take that action and set the amount, and in both the recognition of the severity of the injuries to her and the seriousness of the charge. I have a case many years ago where a young man who was in his 20s thought to present it was a Stewart County case. He thought to try to take one of his friends who was out of line for a ride and straighten him out. He got behind him in the back seat of the car and tied a shoelace around his neck, and thought that was a good prank to try to teach him a lesson. As a result of that, when his friend started turning blue, he kicked him out of the car and panicked and drove off. That man died, and that person is now serving a life in prison as a result of having been charged with first-degree murder. So strangulation of anyone, even in an argument or whatever, is completely unacceptable and is a very serious criminal offense. And for that reason, This court places great importance on the facts that were presented to me, as well as his violation of the prior bond restriction. And I make those findings on the record so that if there is any issue raised about why I have set the bond and made those conditions, it is very clear. That's the judgment of the court.
Okay, friends, we'll go ahead and leave it there for today. It does, if I recall correctly, to Don, I think it was $75K, and he lowered it to 50. So we'll see how that goes. I'll try to keep an eye on this case as it moves through his court if I can, and we'll see what happens. So I hope you all enjoyed the day today. I know I did. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members for the pre-show. Where at least one of the things we'll discuss is the story that Dawn mentioned in the chat with looks like 3 high school football players died in a street race. So we'll check that out and probably talk about some other things too. So go have yourselves a great Wednesday. Look forward to seeing. Let's try that again. Have yourselves a great day. Look forward to seeing you tomorrow. There we go. Not tripping over my words so much. Take care. God bless.